You are listening to Based in Fact, a true crime podcast. Join host Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to Season 4 of Based in Fact, a true crime podcast. We're your hosts, Lisa O'Brien and Kyle Evans, and this is Episode 6, State of Florida versus Dorice Donegan Moore. In November 2009, Florida lottery winner Abraham Lee Shakespeare was reported missing by his family. Abraham hadn't been seen or heard from since early April 2009. Claiming she wanted to help him, Dee Dee Moore inserted herself into Abraham's life in October 2008. By early 2009, it was obvious that her true intent was to help herself to all of Abraham's remaining assets. When the police investigation began, Moore's attempts to cover up the murder led police to a home owned by Moore's boyfriend, where they found Abraham's body buried beneath a slab of concrete Moore had poured on April 13, 2009. Moore was arrested in February 2010 and convicted in 2012. We're going to talk about the evidence against Moore, her ever-changing stories, her antics during trial, and her appellate and post-conviction claims. And good morning, almost afternoon. Kyle, how are you?
I'm doing well. Good morning. How are you, Lisa?
Pretty good. It's just a little earlier than I'm used to.
I made you get up early this morning.
Well, you didn't make me get up early because I'm usually up. I'm just not moving. I don't start moving till around noon. And also on air, I want to wish you happy birthday.
Well, thank you.
You was what, Friday, May 30th?
That's right. Yeah, on Friday.
Cool. It was very nice. You had your kiddos and dinner, and I saw cake.
It's kind of a chill family dinner. It was really
Yeah,
good. It's always a good time to
that's the
spend
way to
time
do
with
it.
the kiddos.
What one is it?
I'm not good to say, but I'm old.
Come on.
I'm
I'm
getting
60. I'm not ashamed.
I'm getting ever closer to the AARP solicitations.
Okay. All right. I can do the math. Yeah. Well, it's fun. It's fun. And now people are, like, look at Metallica. Those
Yeah,
dudes are
that's
all
true.
60.
Yeah, they say, 60's the new 30. Yeah,
So,
I mean, I still remember the controversy. Well, not the controversy, but people were shocked when the Rolling Stones did like their Steel Wheels tour. I think they were 40, and everybody's like, "Oh my gosh, there's Rolling Stones are
uh-huh.
40 going out on tour." And now I think they're touring at 80, and Keith Richards is going to live to be 200, I think.
Yeah, that's probably, yeah. I don't know whether it's good genes or deal with the devil.
Yeah, exactly.
So, I have a high school classmate. He's an attorney, and I have openly said I think he's made a deal with the devil because he has literally not aged a day since we graduated high school.
Wow.
So yeah, there's that. All right, well, let's get started with our episode. We're going to talk about Dorice. I might say Dorice because that's how it's spelled, but I think it's Dorice Donegan Moore. And this is a person like Jodi Arias, Dahlia DiPolito, and a couple of other people who I would not believe if her tongue came notarized. So prepare yourselves because I'm probably going to get really catty about her. All right, so the victim in this case is Abraham Lee Shakespeare. He was born April 26, 1966 in Lakeland, Polk County, Florida. His parents were James Shakespeare Sr., who died in 2005, and Elizabeth Walker, who died in 2023. He also had stepfathers James Powell Sr. and Bobby Big Man Roberson.
Not just as a quick aside, not to
Mhm.
be flippant, but what a great name, like Abraham Shakespeare. That seems like a name that a
Yes.
movie star should have.
Yes, it is. And really, unfortunately, there's not a lot of information about his father or how that name came about. But it probably would be a pretty interesting story. His siblings are James Shakespeare Jr., Robert Brown, Lynette Williams, Archie Powell Jr., James Powell Jr., and Florestine Powell. There may be additional siblings that I did not catch in my research because I believe he has step siblings through both mother and father. Because I've read he was like one of 13 children or somewhere along those lines. So if I've missed any family members, my apologies. He dropped out of seventh grade. Uh, he was a laborer, a day worker. He did have a criminal history for theft, assault and battery, burglary, domestic violence, and violation of injunctions. He had, oddly enough, though, he did not drink or use drugs. So,
Interesting.
um,
That's just rare these days. I mean, not at
yeah.
least not to drink. Have a glass of champagne here and there.
And his children were Moses Shakespeare and Jeremiah Kyler Shakespeare. And his cause of death were gunshot wounds, 2 gunshot wounds to the torso. The perpetrator is Dorice Emma Donegan Dee Dee Moore. She was born July 25th, 1972 in Plant City, Hillsborough County, Florida. Her parents were Patrick Donegan, who died in 2018, and Linda Donegan. She does have one sister. She has a high school diploma. She graduated high school and a CNA certificate. In 1992, she married James Darrell Moore. They were divorced in April 24th, 2009. Um, they have one son, Robert James, who was born in 1995. She worked as a CNA in 1991, but then in 2001, she was working as a saleswoman selling cell phones. She called herself a business owner and an author. Um, Emotional, mental, she's a thief, she's manipulative, she's a pathological liar, and she's a hysteric. Her prior crimes include obtaining property with a worthless check in 2001, insurance fraud and false report of a crime in 2001, fraud in 2001, and theft. She's also been accused of stealing from her cell phone company and from other people who she volunteered to help them start their own businesses. Said they had to pay all this money to start the business. They paid it to Moore, and then Moore put the business in her name, basically. Um,
Crazy.
and it was so hard not to reach out to some of these people and ask them, "Do you want to come on and talk about Dee Dee Moore?" And then her victim was Abraham Lee Shakespeare, who was 43. The crime occurred on April 6, 2009. The victim was Abraham Lee Shakespeare, age 43. His body, however, was not discovered until January 28, 2010. The location of the crime was 5780 State Road 60 East in Plant City, Florida. And then his body was found at 5802 State Road 60 East in Plant City, Florida. These were houses that were next door to each other, and they were in Hillsborough County, Florida. Abraham was in Lakeland, which is Polk County. And Polk County has one of the most entertaining sheriffs, Grady Judd.
Oh yeah.
You can find his briefings on Facebook. They are awesome, hilarious. He does not mince words, and he does not sugarcoat shit. I mean, he tells it like it is. All right. So Abraham lived a simple life in Lakeland, Florida. He worked odd jobs, including riding a garbage truck, sweeping a barber shop, and riding as a helper on delivery trucks to make ends meet and pay his bills. He didn't have much, but he was content. On November 15th, 2006, he was riding as a helper with truck driver Michael Ford. They stopped at a convenience store in Frostproof, Florida, and Abraham gave Ford $2 for 2 quick pick lottery tickets. Before the day ended, one of those tickets proved to be the winner, and Abraham had won the lottery. When you win a lottery, there are generally 2 options: an annuity that pays a set sum at intervals until the total winnings are dispersed, and a lump sum payment. And there are advantages and disadvantages. The annuity, every time you get a disbursement, you have to pay the taxes, and the tax rate is like 32%. So you get a pretty steep tax bill every time they disperse money to you. With a lump sum, you get a reduced amount from the face amount of the prize, but
Right.
you pay your taxes, and then the money is yours to do whatever you want with it. Abraham chose the lump sum method, which meant he cleared $12,700 after taxes. The winnings were $32 million. I think the payout was something less than that. Maybe in the 20 million, 24 million range. And he cleared 12. So almost half of it was consumed by taxes. And remember, he paid all the taxes he owed on this money up front. So he did not owe taxes on this money anymore. Abraham was illiterate and unsophisticated. Although his intent was to do good things for the community, he fell prey to people who needed money and begged him for help. One of those people was Michael Ford, who demanded that Abraham pay him $1 million. In the face of such a demand, Abraham declined. While Abraham did make some investments, including for his son Moses, and bought a house in a gated community in Lakeland, he also gave a lot of money away, made loans to people who didn't honor their agreements to pay him back, and made some extravagant purchases, including buying multiple high-end vehicles, although he bought those vehicles used. But, like he bought himself a BMW, he bought himself a truck, he didn't need multiple vehicles, but he bought them.
But he just got them, yeah.
And and a part of it was he didn't have a driver's license, or he had a suspended license. So, again, he was unsophisticated, so he didn't make
he's
a
just
lot
kind of
of
a sweet, nice guy, but
great
unsophisticated is a
decisions.
really
Yeah.
good word.
On April 24th, 2007, Ford filed suit against Abraham, claiming that Abraham stole the lottery tickets from Ford's wallet. Ford sought damages, and the court entered a temporary injunction against Abraham, tying up his money pending resolution of Ford's claims. Abraham retained an attorney to defend the lawsuit and filed a counterclaim against Ford. The case went to trial from October 15, 2007 to October 19, 2007. And on October 22, 2007, after less than an hour of deliberations, the jury returned a verdict in Abraham's favor. Basically, they didn't find Ford to be credible. They found Abraham to be credible. And it's interesting. I read an article about the trial where apparently Ford was asked, well, I mean, he was stealing 2 potentially losing tickets from you. He didn't know they were winning tickets.
Exactly.
So what's the benefit of stealing from you? Now, if the ticket was pulled and you saw him the next day and the winning one disappeared, that would make sense. But he was claiming he bought the ticket for himself and that Abraham stole it that day. On October 30th, 2007, the judge entered a final judgment and dissolved the temporary injunction, meaning Abraham had full access to his money again. And on November 2nd, 2007, Abraham's attorney filed a motion seeking payment of costs and attorney's fees against Ford, which was granted on April 11th, 2008. Now, again, this comes in, if you go on YouTube, there's a Blue Dot Crime, and there's an interview with Dee Dee Moore, and she's talking about this attorney charging Abraham a huge fee and his money being tied up when she met him, and that's all just bullshit. The case with Michael Ford had finished. It was on appeal, and he could be potentially getting that money for Michael Ford for the rest of Michael Ford's damn life. So again, that's another bullshit story that Dee Dee's come up with. By 2008, due in part to loans that hadn't been repaid and failed real estate ventures, Abraham's net worth had been drastically reduced to $1.5 million in cash and $3 million in property holdings.
Wow, I mean, that's the thing. You feel bad because most of these, it's amazing. You could do a whole episode on most of these lottery winners. It does not really work out well for them over the long term.
Yeah. And he had invested some money, and he had the investment for his son. But he had, and a lot of it he had invested it in a way because he did have promissory notes and things with some of the people he lent money to, but they weren't paying him back.
Right.
And he was going to have to litigate to get it back. In October 2008, Dee Dee Moore Ford's case was on appeal at 2nd District Court of Appeal, and Abraham was facing some minor legal trouble for driving on a suspended license. And he also had, I think, Antoinette Andrews was pursuing him for child support. And Centoria Butler, the mother of Jeremiah, was also going to pursue him for child support, although those weren't really active at that time. They were on the horizon. In October 2008, Dee Dee Moore arranged to meet Abraham, allegedly under the guise of writing a book about him. However, her goal wasn't to help Abraham. It was to help herself to every last dime Abraham had left.
And they did not know each other before.
No.
Is that right? Okay.
No. And there are kind of different accounts. The primary account is it was October of 2008, but it may have been a little bit earlier than that. And Moore was raised in a modest lower middle class household by parents who were not well off, and she'd always craved the high-end lifestyle of the rich and famous. After her marriage in 1992, she lived beyond her means. She held a certification as a CNA, but sold Nextel prepaid. There wasn't some theft from patients or employer. Because being a CNA, you don't go to selling cell phones.
Right.
By 2001, Moore had been banned from selling Nextel products due to a fraud investigation and accused of writing a worthless check to the Hillsborough tax collector's office. On June 14, 2001, Moore was advised that her Lincoln Navigator was about to be repossessed because she hadn't been making the payments on it. And she owed $6,500 on the SUV and a personal credit card. After telling the loan officer that I'll do anything I have to keep it, Moore hid the vehicle in a garage in Pasco County, had a friend tie her up and drop her on the side of the road, and reported to police that she had been carjacked and raped by two, quote, Mexican men. On June 20th, 2001, Moore was arrested for insurance fraud and false reporting. On August 29th, 2001, she was facing charges for insurance fraud, false reporting, and the worthless check. She and her husband were evicted from their rented home. Her former landlord stated that Dee Dee would steal from her own parents if they had any money. They filed bankruptcy on February 17, 2002. Moore's elaborate stories were a fixture in each of her financial and legal troubles. She told landlords and creditors wild stories about people who were out to get her, putting her in fear for her life. She frequently claimed that someone had stolen money from her, but never provided a police report to corroborate her claims. She gave an elaborate statement to police investigating her carjacking and rape claims. All of it was lies. On January 9th,
What a piece of work.
yeah, she is a piece of work. And one of her scams with Abraham was telling him he owed taxes when he didn't.
Jeez.
And another scam with Abraham was telling him that if he gave her all of his money, she would hold it for him, and then Centauri and Antoinette couldn't get it. And he was not sophisticated, so he did not question these things. On January 9, 2009, ownership of Abraham's home was transferred via a quitclaim deed to Moore's company, American Medical Professionals. And this is another thing that I questioned. She called herself a businesswoman. She ran this company, American Medical Professionals. She said they had government contracts. It was like a travel nurse company.
Yep. Visiting nurses. Yep.
But it's like, it doesn't, it's hinky to me. Because when she says they had government contracts, she doesn't identify hospitals or facilities. You know, like we had a contract at the naval base, you know, the naval support activity in Jacksonville or Pensacola or wherever. She just says we had government contracts. But I think Dee Dee was a scammer. And we only know a fraction of the scams.
Right, exactly.
You know. So on January 12th, 2009, Moore formed Abraham Shakespeare LLC as a collection agency. Additional mortgages formerly held by Abraham were assigned to American Medical Professionals PEO LLC, which was also formed by Moore. On January 15, 2009, Abraham allegedly signed an asset purchase agreement selling all of his assets, including $2,180,657.65 in debt owed to Abraham in exchange for payment of $185,000. He allegedly sold his $1 million home for $800,000. On February 9, 2009, Moore formed Abraham Shakespeare LLC, and the difference is the first Abraham Shakespeare was all caps. The second one is lowercase, uppercase, lowercase, traditional. And convinced Abraham to transfer $1.095 million from a Prudential Securities account to the corporate account. On February 11, 2009, she added Shakespeare as a signer on the account. Later, she approached the bank manager and asked him to keep Abraham from accessing the account due to his, quote, drug problems. When the bank manager declined, she returned with new meeting minutes removing Abraham from the account, alleging investigation of criminal activity. Later, she wrote a $25,000 or $20,000 check to the bank officer to buy his silence. He kept the check, gave it to bank security, and didn't cash it. So it became exhibit something in her trial. Once Moore had control of all of Abraham's money and assets, she went on a spending spree, buying properties, including 5802 State Road 60 East, a Corvette for a boyfriend, and a Hummer and new truck for herself, and jewelry. Moore would claim that she purchased all of Abraham's assets for cash so that he could leave town, but her bank records did not show any cash withdrawals from any of her accounts. On March 22nd, 2009, Abraham attended his uncle's funeral and told a friend of his uncle that he was disappointed in how he'd been used by people he thought were his friends and that he wanted to leave Lakeland. This was the last time many family members saw Abraham. His cousin Cedric Edom last saw Abraham on April 3rd, 2009, when Abraham and Moore arrived in a burgundy Cadillac that they wanted to give to Edom. Now, Edom had a loan, and Dee Dee was going around collecting money on behalf of Abraham as well. Edom turned the offer down, and his last conversation with Abraham was by phone later that day. Robert Brown, another one of Abraham's brothers, saw him the same day at a supermarket in Lakeland. At that time, Abraham told his brother that he would have been better off broke. On April 6, 2009, Moore took video of Abraham in which she talked to him about leaving town. This was to make it look like Abraham left town of his own free will. That innocent explanation was made impossible by the fact that A, Abraham stopped using his phone to make calls after April 6, 2009, and B, Moore had the phone in her possession. In reality, when she turned off her video camera, she and Abraham left his home on Red Hawk Bend Drive in Lakeland to meet Judy Haggins at Hard Rock Casino. Haggins had been helping Moore track down people who owed Abraham money and had acted as a personal assistant and driver for Abraham. On the way to the Hard Rock, Moore and Abraham stopped at a property she owned at 5732 State Road 60 East in Plant City. While in the office, Moore removed a .38 caliber revolver from at 5802 State Road 60 East, where she dumped Abraham's body. She covered it with lime, then had James come back near dark to fill the hole. On April 13th, 2009, she had a concrete slab poured over the hole. Now, there is a chance that Abraham had discovered that Dee Dee had been spending his money that she was supposed to just be holding for him. And there is a possibility that there was a confrontation between them that day. But we don't know because Abraham's not here to defend himself. On May 8, 2009, the jury verdict and judgment in Ford versus Shakespeare were affirmed and the mandate issued on May 27, 2009. The motion awarding costs and fees to Abraham that had been stayed pending appeal did not go forward, likely because Abraham's death prevented his attorneys from pursuing it further after the verdict was affirmed on appeal. For the next 7 months, Moore told elaborate stories about Abraham. She told people he was away seeking treatment for AIDS. She claimed he was hiding from drug dealers who didn't want to pay back money he'd loaned them. Over the next week, she sold or gave away Abraham's vehicles. She also used Abraham's phone to send text messages to his friends and associates. So this is an illiterate man sending text messages to people. In August 2009, she paid Edom $5,000 to deliver a card to Shakespeare's mother for her birthday. Moore later told Miss Walker that she would see her son in August. That didn't happen. On August 11, 2009, Abraham was a no-show at a child support hearing in a case filed against him for support of his youngest son, Jeremiah. On November 11, 2009, Moore repossessed Cedric Edom's car. Edom reported to Lakeland police that Moore had used Officer Troy McKay Young to intimidate him. An investigation revealed that Young was helping Moore by running license plates for her for a fee. It was then that Edom had decided to make a missing persons report to police. It was Moore's efforts to cover the murder and misdirect law enforcement that put her directly in their sights. When her attempt to get Edom to retract his report, which he refused to do, failed, she got creative, offering people money to say they'd talked to or seen Abraham at various times after April 6, 2009. She sent elaborate texts from Abraham's phone, which drew suspicion because Abraham couldn't read or write. In her first interview with financial trouble before she ever met him. She also claimed that Abraham sold her all of the debts owed to him and all of his assets. She stated that Abraham had become disgruntled with people asking him for money and that she'd bought his assets and debts. When she couldn't provide proof that she'd paid him $840,000, as she initially claimed, she changed her story and claimed to have given him $500,000 in cash. After her next interview on November 25th, 2009, Moore admitted to sending text messages to Abraham's family and friends. She was interviewed again on December 3rd, 2009, and confirmed that she had Abraham's phone. She then claimed that Abraham had told her to text people after he left using his phone. She also admitted to asking other witnesses to lie to investigators about seeing Abraham. She also claimed that she and Abraham transferred the money so that he could avoid paying child support. And, you know, I think most of these interviews are available online. And they are just mind-boggling.
Yeah, she seems like a piece of work. Just is the tip of the iceberg.
Yeah. And the funniest thing is, like, she'll be confronted, and initially she'll double down, and then she'll be like, okay, I'm lying. And then she'll come up with another lie.
Well, and that's the
Spoiler
thing.
alert.
Yeah, it's like the old maxim is true. It's like the cover up is always worse than the crime. I mean, you can always, we've said before, I think you can tell a lot. It doesn't necessarily point as evidence of guilt, but you can always tell the way these people act, whether they're lying, changing stories, constantly coming up with something new. It just speaks to the overall veracity of the guilty.
Well, and the other thing that is hilarious to me is that, some of these people are like, okay, I lied, like Jodi Arias and Dee Dee Moore, but now this is the truth. Now I'm telling the truth.
Yeah, don't ignore my previous 100 lies. Now I'm being honest.
And
until I'm not.
Hence I wouldn't believe her if her tongue came notarized. If she said the sky was blue, I would go outside and look.
And verify it.
After the December 3rd, 2009 interview with law enforcement, Moore tried to sell her Hummer for quick cash, but was unsuccessful. She sold it to a friend of the dealership's owner for $49,000, paid in 3 checks, $45,000 and 2 checks payable to Moore, and 1 check for $4,000 payable to her mother. On December 5th, 2009, Moore began posting on a web sleuth's message board about Abraham's case, playing the victim and claiming that Abraham was in financial trouble when she met him. On December 6, 2009, she offered $10,000 for, quote, someone to take him to the nearest sheriff's department for me, unquote. She also began throwing others under the bus, making baseless allegations about Abraham and his associates. And the biggest one is that he did drugs when everybody else says, nope, he didn't do drugs. That wasn't his thing. Moore later admitted to the media that she helped Abraham disappear. On December 27, 2009, Moore took Miss Walker to dinner, and while they were at the restaurant, Miss Walker received a call from Abraham. Miss Walker didn't fall for it and notified detectives, who traced the number to Greg Smith, a barber and friend of Abraham's. On December 28, 2009, while investigators were following Greg and waiting for the right time to stop him so they could have a little chat, to their surprise, they followed him to a meeting with Moore in the parking lot of a mall. Once Moore left, police pulled Greg over for the chat. Like Miss Walker, Greg was no fool and agreed to help police nail Moore. He devised his own method to secretly record his meetings with Moore and got right to work. On January 6, 2010, while being recorded by Greg with his help, Moore crafted an elaborate letter to Miss Walker to be delivered by Smith. Of course, Moore referenced that 12/27/2009 phone call at the Cracker Barrel and expressed indignation that she didn't recognize her own son's voice. That same day, she tells the media that she wants Abraham to return and clear up the problems his disappearance has caused her. On January 21st, 2010, Moore asked Greg to help her find someone willing to take $50,000 to admit that they murdered Abraham. Greg says he has a cousin facing federal charges who needed money to take care of his family while he's in prison. And then in steps Mike Smith, no relation to Greg, of the Lake Wales Police Department, who meets with Moore and Greg and agrees to help Moore out. Mike proposes moving Abraham's body so that the story he tells police has some truth to it, and Moore agrees to that plan. On January 25th, 2010, Moore meets with Greg and gives him the .38 caliber revolver she used to kill Abraham. They also discuss the story to tell implicating a drug dealer named Ronald in the murder. She then takes him to 5802 State Road 60 East and points out the exact spot under the concrete slab where Abraham's body will be found. To aid in the movement of Abraham's body, she parks a truck and utility trailer to block anyone from seeing the slab from the roadway. She also tells Greg that Abraham was killed in her office at 5732 State Road 60 East. Finally, she provided a trough to use to move the body, gloves to avoid leaving evidence, and several gallons of fuel and bleach to destroy evidence and or the body. The plan is for Greg and Mike to move the body that night at 8 p.m. Moore is interviewed again on January 25th, 2010 by the Polk County detectives. At that time, she tells them that drug dealers killed Abraham with her handgun at her office in Plant City over $200,000. She says that one of the drug dealers was named Ronald. When confronted with the fact that she made Ronald up in a discussion with Greg, she implied that her 14-year-old son killed Abraham. Later, she asked if she could keep all of her things if she told the truth about who killed Abraham. During that interview, Moore admits that she didn't fully pay Shakespeare for his home or assets she allegedly purchased. One detective said, "Everything you've told us since you've come into this room has been a complete lie." Moore's response was, "I know." She later claimed that Abraham gave her everything as a gift.
Sorry, she's just
I know.
There's some people are just so, it's just, I don't know, it's ridiculous.
Yeah. On the same date, Troy Young was arrested for unlawful compensation and misuse of confidential information. The investigation had shown that Young advised Moore on legal questions, witnessed her opening a safe deposit box, provided her with information obtained through law enforcement databases, and information on identities of vehicle owners from tags she provided. He gave up his 19-year career with Lakeland PD for $200 and a plane ticket for his daughter, purchased by Moore. And I think he served a little bit of time for that. So another life ruined by Dee Dee Moore.
Yeah.
On January 26, 2010, Hillsborough and Polk County executed search warrants at 5802 State Road 60 East and 5732 State Road 60 East in Plant City. On January 28, 2010, Hillsborough County deputies found Abraham's body under the slab where Moore said it would be. His body was more than 5 feet deep. He was identified by his fingerprints due to the state of decomposition. Moore was interviewed on the same date and admitted that the gun she gave Greg was hers. Ballistic tests showed that the bullets recovered from Abraham's body bore similar class characteristics to bullets from Moore's gun, but a more precise ballistic match could not be made due to degeneration of the bullets recovered from Abraham's body, which is not unusual. The case was officially transferred from Polk County to Hillsborough County because Abraham was murdered and his body was found in Hillsborough County. However, Polk County investigators continued to participate in interviews with Moore and other witnesses. And this is also because a lot of the financial crimes took place in Polk County. So, just to kind of recap, we have search warrants on January 26, 2010 at 5802 State Road 60 East and 5732 State Road 60 East in Plant City. Abraham's body found on the 28th. On January 29, 2010, Moore was interviewed again. She admitted to asking James to dig the hole behind 5802 State Road 60 East. She admitted that Abraham's body was buried in the hole. She stated that James did not know about the body being placed in the hole. She claimed Abraham was murdered by 1, a drug dealer, 2, Cedric Edom, 3, her 14-year-old son RJ, and 4, that she shot Abraham in self-defense. So in the course of that single interview, she gives different stories. She was interviewed again on the 30th. She claimed attorney Howard Stitzel shot Abraham and arranged to bury him on her property. Moore said that Stitzel was a drug addict and owed Abraham money for legal work he'd failed to perform. Moore claimed that on April 6, 2009, Stitzel and 2 unknown male drug dealers, whose races changed from white to black Hispanic, came to her office. Moore claimed there was an argument and that Shakespeare pulled a gun to shoot Stitzel, but his gun malfunctioned. Moore said that Stitzel or one of the men with him grabbed her .38 and shot Abraham. Moore claimed Stitzel left with one of the drug dealers and told her to dig a hole, and the other one told her to dig a hole and that he would take care of Abraham's body. In all versions of Moore's story, she said Abraham was shot twice. A search warrant was conducted on January 31st, 2010 at 8704 Turkey Creek Road. I have Creed, sorry, in Plant City. That may have been her parents' house or where she had been living prior to moving into Abraham's house. And there was probably a search warrant at the Red Hawk Bend, and I didn't capture that. On February 1st, 2010, Moore gave several media interviews, and some of them may have been earlier, but they were published on the 1st. She told the Lakeland Ledger that she admitted that she covered up Abraham's death but denied killing him, denied stealing from him, and said that she would go to jail and prove her innocence. Moore claimed that everything I did as far as money was done before Abraham went missing, and it was done with his full acknowledgement and consent. She claimed Abraham had enemies and that she'd shared that information with law enforcement. And she said that there were at least 2 killers and at least one of them knew Shakespeare. Moore told WESH that the money was like a curse to Abraham, and it's become a curse to me. This is where the hysterics come in, like the proving her innocence. Moore in Fox 13 Tampa Bay, Moore denied killing Abraham, stating, "I would never pull a gun on another human being in my life." Moore said, "I never did anything unethically or unprofessionally or anything he didn't want done." And then finally, she told the Tampa Tribune that she wanted to attend Abraham's funeral, but was waiting to find out whether that would be too upsetting to his friends. On February 2nd,
probably just keep her mouth shut.
she is incapable of doing that. And it's kind of like the Ron White joke. I knew I had the right to remain silent, but I didn't have the capability. So she was arrested by Hillsborough County Sheriff on February 2nd, 2010. The case was filed under docket number 10 CF 001733 in the 13th Judicial Circuit in and for Hillsborough County, Florida. She had several judges over the course of the pretrial period. The first was R. Walter Heinrich. The second was Daniel H. Sleet, who withdrew due to a conflict later in the pretrial period, and then Ronald N. Ficarrata. She was represented by public defender Julianne M. Holt, who ultimately withdrew due to a conflict. And that may have been because there were potential witnesses from the jail that Holt was representing that were going to testify against Moore. Stephen B. Fisher and Matthew Wells, who were regional criminal and civil conflict counsel for the 2nd District in Florida. Randall O. Reeder, who had a temporary special appearance as to civil matters. She represented herself pro se because she can't take advice from others and she has to do what she wants to do. And then ultimately, she was represented by Byron Heilman, who was assistant regional counsel and the chief of the homicide division, and Christopher E. Bolt. Jay Pruner was a state attorney, and he followed the case entirely through the prosecution. A criminal report and affidavit and notice to appear were filed on February 2nd, 2010, charging her with accessory after the fact and first-degree murder. Probable cause was found on February 3rd, 2010. Her bond was set at $1 million on the same date. Abraham's funeral was held February 6, 2010. It's called Celebrating the Life of Mr. Abraham Shakespeare, 1966 to 2010, because that was when he was found. And that was at the New Bethel AME Church and the Coney Funeral Home. A search warrant was executed on February 8, 2010 at Red Hog Bend in Lakeland, which I did, so I did capture it. Yay me. Criminal report, affidavit, and notice to appear were filed on February 19, 2010, dropping the accessory after the fact and charging Dee Dee with first-degree murder. An indictment capious issued on March 11, 2010, murder in the first degree. Dee Dee was arraigned on March 17, 2010, and pled not guilty. On July 21st, 2010, an order was entered regarding the defendant's motion to preclude disclosure of information pursuant to Florida Statute Section 119.0712E, and that was in Florida, the discovery is public record. And so basically this is a procedure put in place by the court for the defense to see the discovery and object to public release of anything that they didn't want out in the public. And the court would determine whether that was legitimate or whether it was something that couldn't be withheld. So they basically set out a procedure to do that. So if if one of Dee Dee's complaints is in Florida, everything's public. But honey, you had your chance. Your attorneys had the chance to see what was going to be released before it was released and keep anything that didn't need to be out there. A hearing was held on September 15th, 2010, granting the motion to preclude disclosure of information. So whatever was put in place in that order became final. The state and defense entered stipulation to release unobjectional discovery materials in November of 2010. Then in 2011, on August 19, 2011, Moore's attorney Reeder filed a motion to return property. She was seeking return of property seized during the searches of a property. Oh wait, that's the wrong address. That's the Turkey Creek property. Sorry. And she also filed pro se a petition for habeas corpus on August 22nd, 2011, challenging her solitary confinement status, which is due to, quote, manipulation of other inmates, false accusations against staff, and your repeated attempts to garner media attention that jeopardize your safety. That was denied on August 22nd because she failed to notify the Hillsborough County Sheriff's Office. On September 19, 2011, a second motion to return property was filed. And that was amended to add company business records seized from the Red Hawk Bend Drive and property that was at the Turkey Creek Road residence, which was allegedly owned by Moore American Medical Professionals. And, a lot of it was jewelry purchased after she murdered, or before she even murdered Abraham, after she got control of his money. And Reeder, who is a civil attorney who has no business involving himself in a criminal case, fucked up because he prepared an affidavit and had Dee Dee sign it, and it was notarized. And in it, she made some claims. that she resided at the Red Hawk Bend Drive property from April 2009 until her arrest in February 2010, that she owned all personal property at the residence, that she acquired all of Abraham Shakespeare's personal assets and all the assets of Shakespeare and Associates LLC by agreement entered in January 2009, that she paid him in cash for those assets, that she owned the personal property at 8704 Turkey Creek Road, and that all items listed in the exhibits attached to the motion for return of property were her personal property. Now, that she paid him cash is contradicted by the fact that she admitted that she never paid him, or didn't pay him fully, or didn't pay him, in her interviews. On October 3rd, 2011, there was a hearing held on the motion for return of property. They may have been also, it was a motion or motion to return property, which was postponed because regional counsel did not appear due to a conflict in scheduling, and Judge Sleet did not want to proceed without them present due to Moore's affidavit, which had statements that were inconsistent with her prior statements and could be used by the state in her criminal trial. On October 13, 2011, Drake Sheriff Judd in Polk County filed an objection to return of any property held in Polk County prior to the conclusion of defendant's criminal trial, which was everything from the Red Hawk Bend property. On November 17, 2011, the motion for return of property was reset to the 28th of November and transferred to Division G due to a conflict for Judge Sleet. But what that is, we're not sure, because the record just notes that there was a conflict, but it doesn't identify it. Then there was a hearing on November 17, 2011 in a State of Shakespeare versus Moore, which was a civil case filed against Moore. And that was to decide Moore's motion to dismiss, which was denied as to the count for conversion, and the action was abated as to the replevin count, leaving it to the criminal court to elect which court will decide ownership of the property. So basically, everything as far as the return of property was put into abeyance.
Such a great word. That's one of my favorite words, abeyance.
And then in November, Reeder filed filed the 919 motion in the criminal case again, and set it for hearing it was set for hearing on December 12th. He filed an amended motion, which was substantially similar, with additional description of property and records. A motion for leave to file a response was filed by the Shakespeare estate, basically saying that they had a pecuniary interest in the outcome of the motion because they have filed an action in the circuit which alleges that Moore converted in excess of $1 million that was the property of Abraham Shakespeare, and seeks replevin of the property sought by Moore. They were also trying at that time to reverse the asset purchase agreement and the transfer of the Red Hawk Bend property. Which I could not capture everything because a lot of it was in Polk County, and there you can't access documents, you can just see docket entries. Polk County, I wish they'd get their documents online, please. And then on the same date, they filed a response to the amended motion. And they said that the return of the property to Moore would intrude upon the concurrent jurisdiction of the civil court. On February 10th, 2012, a pretrial conference was set for July 10th, 2012 at 8:30 a.m. and an initial jury trial setting of July 16th, 2012 was put in place. There's a notice of reassignment of counsel assigning Byron P. Heilman. A motion to continue trial was filed by Moore on April 23rd, 2012, which was not objected to by the state, and they agreed to a 6-month continuance of the jury trial. A hearing was held on April 30th, and the motion to continue was granted. The criminal trial, the pretrial was reset to November 13th, 2012, and the trial was reset to November 26th, 2012. On October 9th, 2012, Moore's counsel filed a motion to appoint a committee to evaluate defendant to determine her competency to proceed. And in it, they stated the undersigned states that in good faith he has reason to believe the defendant suffers from mental and perceptual disturbances which substantially impair her capacity to understand the advice of counsel and impede her ability to meaningfully assist in her defense, which is there was a mistake in scanning and a page seems to be missing. Then an order was entered on October 11th, appointing two a PhD and an MD to examine Moore. I think in addition to the defense doctor requested in the defense motion, although that doctor's name isn't included in the order. And basically what they want to do is evaluate Moore for her capacity regarding her competency to proceed and her capacity to appreciate the charges and allegations against her, to appreciate the range and nature of possible penalties which may be imposed against her, her understanding of the adversarial nature of the legal process, disclose to her attorney facts pertinent to the proceedings at issue, her ability to disclose, her ability to manifest appropriate courtroom behavior, and her ability to testify relevantly. And then they set out if she's determined that she's not competent to proceed, they need to identify the mental illness causing incompetency, the treatment or treatment's appropriate, the availability of acceptable treatment, and if treatment is available in the community, the likelihood of her attaining competency under the treatment recommended, and an assessment of the possible duration of the treatment required to restore competency. On October 18th, Moore filed a motion to suppress, several motions to suppress, seeking to suppress her statements recorded by Cedric Edom, statements surreptitiously recorded by Satoria Butler, statements surreptitiously recorded by Greg Smith, and her interviews on January 29, 2010 and January 30th, 2010 with Wallace and Thomas at the Hillsborough County, with Detectives Wallace and Thomas at the Hillsborough County Sheriff's Office, because in December, an attorney had sent a letter for Moore invoking her right to counsel. And then they also argued that law enforcement referenced the death penalty, they threatened to arrest her ex-husband, and they mentioned the potential arrest and loss of custody of her son during the interviews. So they bullied her into making a statement or coerced her into making a statement. On the 25th of October, she filed a motion to preclude improper argument and tactics. And that's basically just saying the prosecution can't do certain things in their opening and closing arguments and presentation of the case. And it's kind of a boilerplate pleading. Then they filed a motion for individuals sequestered voir dire regarding pretrial publicity. On the same date, they filed an amended motion to suppress, correcting the first item to be suppressed. They filed an amended stipulated order appointing experts to determine competency, which was appointing a different PhD in place of Dr. Donald Taylor. And then the state filed a motion to exempt Greg Thomas from the rules of sequestration on November 2nd, 2012, so that Detective Thomas could sit at counsel table and assist with the prosecution. A competency hearing was held on November 2nd, and then the competency hearing continued on November 19th, and the motion to suppress was also heard the motions to suppress were heard on November 19th. Orders were issued on November 26th, finding Moore competent to stand trial, granting the motion to suppress statements recorded by Edom, denying the motion to suppress statements recorded by Centoria Butler, denying the motion to suppress her statements to the investigators, granting the motion to preclude improper argument and tactics, granting the motion for improper sequestered voir dire, and granting the motion to exempt Greg Thomas from the rule of sequestration. And I believe they also, I may have missed an order in there. I believe they also denied the motion to suppress Greg Smith's recordings. And then the trial was held in the same circuit court, same docket number. The judge at trial was E. Lamar Battles. Jay Pruner was still representing the state, and Moore was represented by Byron Heilman and Christopher E. Bolt. The guilt-innocence phase began on November 26, 2012, and continued until December 10th, 2012. And Moore's behavior in the courtroom, which included crying, gesturing, shouting, and trying to communicate with jurors with facial expressions gestures, drew multiple admonishments from the judge, who threatened to eject her from the proceedings. After one dressing down, she claimed to have suffered anaphylactic shock the night before after being given bacitracin for a kidney infection, and she complained about cuts on her ankles from being cuffed every day. The defense entered a motion for judgment acquittal and renewal of all motions and objections, which were denied. They then rested without calling any witnesses. Jurors deliberated a little more than 3 hours before returning with a verdict of guilty on charges. So on December 10th, 2012, they found Dee Dee Moore guilty of first-degree murder and possession discharge of a firearm. She was sentenced the same day to life without parole, which was the mandatory sentence for the first-degree murder charge, and 25 years for possession of a gun during a violent felony. And Judge Battles made a statement, and I wish I could find the video of it because it was really good. But I did find an account of it. I will make just a very brief comment, Ms. Moore. After trial, listening to all of this over 2 weeks, words that were said here, cold, calculated, cruel, they all apply. Manipulative, probably the most manipulative person that this court has seen. Abraham Shakespeare was your prey and your victim. Money was the root of the evil that you brought to Abraham, and now I'm going to pronounce the sentence. For the murder of Abraham Shakespeare, you are sentenced to life imprisonment, and you shall not be eligible for parole. To the extent Chapter 775.087 requires it, I will also pronounce a 25-year minimum mandatory pursuant to that statute. The sentence of life without parole is also mandatory. Moore filed a motion for new trial on December 28, 2012. Excuse me. And she argued that the defendant was found guilty by jury verdict of one count of premeditated first-degree murder as charged in the indictment. She was adjudicated and sentenced to life without the possibility of parole on the same date, and that the indictment was predicated on exclusively a theory of premeditated first-degree murder, not felony murder. The evidence in the guilt phase was all purely circumstantial and was legally insufficient to prove the guilt of the defendant beyond any reasonable doubt as a matter of law. The state did not offer substantial competent evidence to exclude every hypothesis of innocence. The clearest of several hypotheses of innocence was clearly placed in evidence through about 20 hours of video or audio taped oh, sorry about that, Kyle. All right, sorry. I didn't even realize you were off the stage.
No worries. So I have a touch screen, and sometimes I accidentally move and it just like closes stuff down, and then it's crazy.
And I think you were trying to get my attention, and I'm looking at my notes. I'm really sorry.
No worries. No, I know it's hard.
So in fact, you might want to, because my phone has an audible Next time, just text me immediately
Sounds good.
so that I immediately know that something bad has happened. But at least you're still awake. So, um, the clearest of several hypotheses of innocence was clearly placed in evidence through about 20 hours of video or audio tape statements by the defendant in police interrogations and undercover meetings surreptitiously recorded, and in recorded phone calls and via cross-examination of state witnesses. That hypothesis of innocence, in summary, set forth before the jury by such evidence as that the defendant had knowledge of the murder by being present or present shortly thereafter, that she then may have helped to cover up the crime, including assisting in burying the body or allowing it to be buried on her property. However, such participation after the fact of the murder itself was allegedly undertaken by defendant under extreme duress, consisting of threats of death to herself and her son from the drug dealers who actually killed Mr. Shakespeare, and a drug deal gone wrong if she spoke to police. Defendant knew she would be suspect due to prior financial dealings she had with Mr. Shakespeare. That duress was augmented by the fact that the actual murders used a weapon from her safe in her office to commit the crime and forced her to undertake a role which incriminated her by participating in the cover up. Thus, the murderers had laid a groundwork for, quote, framing her, unquote, for the murder. The defendant did, as shown by the evidence, and after the homicide investigation began in November 2009, and while under continuing duress previously described and faced by the intense suspicion of investigating authorities, utilized subterfuges after the fact to try to divert the homicide investigation because she believed she would be the prime suspect and be arrested due to all the facts stated above. The defendant telling authorities the whole truth was not an option due to her fear for her son's life. Accordingly, the court erred in denying defendant's motions for judgment of acquittal. Now, let's just recap here, okay? Shot with her gun, buried on her property. It was in her boyfriend's name, but she paid the taxes.
Right.
So, buried on her property, shot in her office on another property. In with him that night, and everybody she tried to throw under the bus, like one of the people she tried to throw under the bus wasn't even in Lakeland or Plant City that night. I think that was Cedric Edom.
Yeah, I mean,
And what's funny,
she seems so obviously guilty. I mean, the fact that she could even dispute it's crazy.
yeah. But just continuing to double down on this story is just, it boggles the mind. Assuming without admitting that the court rightly found that the purely circumstantial evidence adduced by the state was legally sufficient to prove that Miss Moore was the killer of Mr. Shakespeare, no principal theory having been asserted by the state, beyond and to the exclusion of any reasonable doubt, nonetheless, the court erred in not granting the defendant's motion for judgment of acquittal on the count of premeditated first-degree murder based upon the total absence of substantial competent evidence showing that defendant acted with premeditation by having either the time or under circumstances which permitted calm reflection. Indeed, the state produced through its witnesses, banker Mr. Douglas Hancock, suggested evidence that shortly before the murder, defendant called him crying and upset, saying Shakespeare had tried to kill her by choking her. Thus, the element of premeditation was based solely on speculation, assumption, and surmise, and not proven by competent, substantial, credible, circumstantial evidence at trial. Well, you know what? She called him a few days before and said he tried to strangle her. Well, maybe that's why she decided on the 6th to get her gun and shoot him. After thinking about it, I mean, she had taken all his money and she had by this time spent most of it, or a very good bit of it. So the court should have precluded the count of premeditated first-degree murder and left the applicable lessers for the jury's determination. That the court erred as a matter of law in denying the defendant's motion to suppress several illegally intercepted or involuntarily provided statements and recorded phone calls. There was a hearing held on January 7th, 2013, and the motion for new trial was denied. Moore filed a motion for a notice of appeal on the same date. An order of insolvency and appointing the Office of the Public Defender of the 10th Circuit for appeal was entered on the same date. A statement of judicial acts to be reviewed was also entered or filed by Moore. They were challenging the competency hearing, the motion to suppress, the jury trial, the sentencing conducted on the 10th, and the hearing and ruling on the motion for new trial on January 7, 2013. And they also filed directions to the clerk which designated non-substantive items that could be excluded from the record on appeal. The direct appeal was Dorice Moore versus State of Florida. That was in the District Court of Appeals, 2nd District, case number 2D13-307. Moore was represented by Howard L. Dimig and Jose Rafael Rodriguez. The state was represented by Catherine Coombs Klein, who was an assistant attorney general. Her notice of appeal was filed, either the filing from the trial court was filed on the 21st in the appellate court, or she filed a new notice in the appellate court. It's not available. Get your act together, Florida Courts of Appeals. You can make those things available now. An order was filed on January 24th, vacating the courts assigning the 10th Circuit Public Defender and ordering Judge Battles to appoint the 13th Circuit Public Defender within 15 days. They also ordered, Moore to file an amended notice of appeal within 15 days that identifies the date of the order for which review is sought. A miscellaneous trial court order was filed on the 28th of January, transferring the indigent representation to the 13th, or actually to the Office of Criminal Conflict and Civil Regional Counsel. And I think that's because the 13th District Public Defender has a conflict. So it goes to the Criminal Conflict Counsel instead. That was why he appointed the 10th initially. Moore filed her amended notice of appeal on January 31st, 2013. The record on appeal was lodged on November 6th. Initial brief was filed on June 10th, 2014. Supplemental records were filed on the 15th and 17th of September. The state filed an answer brief. There was a disposition on March 4th, 2015, and they affirmed without written opinion. The mandate issued on March 31st, 2015, and her conviction and sentence became final on August 7th, 2015. She did not request review by the Florida Supreme Court, and she didn't file a writ to the U.S. Supreme Court. And so August 7th is and there might have been a request for rehearing that I missed. But anyway, and then she began the state post-conviction process, and this is where it got totally out of hand. I'm sorry.
It seems like that seems like a common theme. Everything with this woman is out of hand.
Yes, and part of the reason it's out of hand is because Dee Dee was representing herself pro se. So the level of crazy was epic. So it goes back to the same case in the trial court, circuit court of the 13th Judicial Circuit in Fort Hillsborough County, same docket number. The judge by this time is the Honorable Michelle Cisco. Moore represented herself pro se, although later a public defender was appointed and stepped in to represent her briefly. The state was represented by Ronald Gale. Moore filed her motion for order of appointment of public defender on January 3rd, 2017, basically arguing that her lack of education and advocacy skills, due to her lack of education and advocacy skills, she cannot reasonably and intelligently represent herself and the issues at hand. She wants to avoid being procedurally barred at advanced judicial levels due to her intellectual inadequacy and lack of skills. She needs counsel to present valid argumentation. She's indigent, owns no business, and nor has any partnership in business, and does not own any real property. She's not divested herself of any property or funds for the purpose of avoiding payment of filing fees, costs, or attorney's fees. And she did do that before she was arrested. Now her grounds are that her appeals lawyer never spoke with her and failed to add things she felt were important to her case. She alleged ineffective assistance of counsel for failing to allow her to testify and call witnesses, for failing to request a mistrial due to jury tampering, for misadvising her on how easy it would be for her to get a new trial if her attorney failed her. Her counsel were ineffective for not properly presenting evidence, not presenting DNA evidence proving Abraham was alive on April 6, 2009, when she had concrete poured on April 13th, 2009, or after April 6th. Failing to show bank statement proving purchase of ISBN numbers to write a book in March of 2008, which kind of, sort of, makes me wonder if she was setting this in motion sooner than October when she allegedly first met. Failing to explain to the jury by having his own gun expert take the stand with that no identification value for comparison purposes to a specific firearm. Failing to explain that no blood was found on the gun. Due to the cumulative effect of counsel errors on both state and appellate lawyer, she requests the court give her counsel to properly file her motion for post-conviction. State also kept changing her attorney for no reason, and her judge as well. They refused to give specific reasoning why they kept revolving. That gives you an idea.
Insanity.
And then on the March 8, 2017, she filed an identical motion for order appointment of public defender. She also filed her motion for post-conviction relief. And that was ineffective assistance of counsel for failure to investigate and present exculpatory evidence, failure to allow her to testify, failure to request a mistrial due to jury tampering, and failure of appellate counsel to even call her before submitting her appeal. The facts on which she bases this are that she could have shown specific evidence substantial enough to show the men were real that threatened her. One man's DNA was even at the crime scene. Her attorney would not look up cell phone bills to connect people involved or investigate witnesses. He said we didn't need it. Byron Heilman reiterated to me in front of Officer Brock, who agreed to testify for me if I lost my trial, because she could not believe what she heard him say. I was not taking the stand, Byron told me. He was not calling any witnesses because he refused to be micromanaged. We did not need it. Greg Smith stalked 3 jury members on the way to their car. After that, jury members were taken to the car every single night, but counsel failed to advise of the probable consequences of proceeding with the trial. I am completely innocent, and he knows it. Appellate attorney failed to cover all the facts to appeals court and discuss it with client after her trial when he had several points she wanted to an appeal. On June 8, 2017, Antoinette Andrews won $1 million on a $20 scratch-off Monopoly lottery ticket. She claimed a one-time payment of $770,000. On September 12, 2018, Dee Dee wrote a letter to the judge. And basically said, this letter is not asking for sympathy or meant to manipulate you in any way. which is kind of like saying, I'm going to be honest.
Yeah, here it comes. I'm manipulating you and I'm asking for sympathy.
Please do not twist my heart being poured out onto my paper. My dad died not being able to see me found innocent. Please let me prove I'm innocent in a court of law before something happens to my mom. The justice system has failed me, and I should not have to wait until the Supreme Court overturns my case when I have so many of my rights violated you can prove. I swear on the Bible that I did not hurt this man in any way, shape, or form. I can't even kill my own self because I can't go to heaven if I do. My heart goes out to Abraham's mom. She's a wonderful person, and I feel very sorry for her, but I am not in any way responsible for his death. I should have never let him bury money on my property, but taking away my life does not bring him back. Please stop this injustice now and allow all my evidence to be heard. I'm just asking for the truth to come out, not any favors, and justice to prevail. She filed an amended motion for appointment of counsel on September 19th, 2018, which provided additional facts that supported her post-conviction claims and her request for appointment of counsel, and challenging the evidence used against her at trial, which I initially bullet pointed like I did this one, bullet pointed the others, and I just couldn't do it. So I said no. But it's more crazy, more Cedric Edom killed him, drug dealers, I can prove it, Centauri Butler lied, all these things. She filed an amended motion for post-conviction relief on October 9th, 2018, alleging a Brady violation, basically that she was not given her entire discovery or investigation. And I saw that one that time. And asserting additional facts supporting her post-conviction claims and challenging the evidence used at her trial. An order dismissing her motion for order of appointment of public defender and motion for post-conviction relief was filed, and also dismissing without prejudice in part and denying in part her amended motion. And this is, the court's findings are quite detailed, but I think it's important, given her pro se allegations, to go through why the court ruled the way it did. The court first finds that defendants' requests for counsel in these post-conviction proceedings are premature. There is no constitutional requirement for the appointment of individual counsel for an application for post-conviction relief until a colorable or justiciable issue or meritorious grievance prima facie appears in the appellant's petition. Under Graham versus State, in deciding whether to appoint counsel for an indigent defendant filing a post-conviction motion, the trial court should consider the adversary nature of the proceeding, its complexity, the need for evidentiary hearing, and the need for substantial legal research. Here, the court has not yet determined whether an evidentiary hearing will be necessary on any of the claims filed by defendant. Thus, the issue of whether defendant is entitled to counsel is premature at this time. Consequently, all three of defendant's motions requesting appointment of post-conviction counsel are subject to being dismissed without prejudice for the defendant to refile her request at the appropriate time. Thus, although defendant's October 9, 2018 amended motion was not filed within the 2-year filing period provided for in Rule 3.850, because the allegations enlarged previous timely filed claims, the court finds that the expiration of the 2-year period does not preclude the court from ruling on the amended motion. And furthermore, because defendant's October 9, 2018 amended motion realleges and enlarges the claims set out in her initial motion, the court finds that it will dismiss defendant's March 8, 2017 motion for post-conviction relief and proceed solely on her October 9th amended motion. In Sparrow versus State, the Florida Supreme Court held that in dismissing a first post-conviction motion based on a pleading deficiency, a court abuses its discretion in failing to allow the defendant at least one opportunity to correct the deficiency unless it cannot be corrected. Accordingly, Claim 1 must be dismissed without prejudice to any right defendant may have to file within 60 days, timely, properly sworn, facially sufficient allegations, subject to all filing requirements and limitations outlined in Florida Rule of Criminal Procedure 3.850. Next, based on defendant's responses to both the judge and her attorney, the court finds the record refutes defendant's allegations that she was coerced into not taking the stand at trial. Defendant, under oath, was specifically asked by the judge if she was forced, bullied, or coerced into her decision, and she responded negatively. She was specifically asked if her decision was voluntary, and she responded positively. She acknowledged to both the judge and her own attorney that it was her decision whether or not to testify. She stated, still under oath, that her attorneys advised her that she could do whatever she felt was in her best interest and that her attorney did not try to force her to change her mind. Defendants, like all other parties that appear before the court, owe a duty of candor to the tribunal. A plea conference is not a meaningless charade to be manipulated willy-nilly after the fact. It is a formal ceremony under oath memorializing a crossroads in the case. What is said and done at a plea conference carries consequences, just as allocution of your decision whether or not to testify is the same thing. Thus, based on defendant's responses to the questioning by both the judge and her attorney, the court finds the record refutes defendant's allegations that counsel acted deficiently for not allowing defendant to testify on her own behalf. Accordingly, relief is not warranted on Claim 2. The court finds the record refutes defendant's allegations. As to the first instance of jury tampering, the record shows that a bailiff was approached by a juror who felt uncomfortable the last time she left the courthouse. The judge then brought in all of the jurors and asked them if anyone had some concerns about leaving the courthouse, and 3 jurors raised their hands. 2 of the jurors stated someone watched them and they identified this person as the last witness who testified on the prior Friday. The 2 jurors stated, however, they could still be fair and impartial. The 3rd juror identified people sitting in the gallery as being the possible person who watched the jury exit the courthouse. She testified if any of those persons eventually testified at the trial, she would be able to fairly weigh their testimony. After the questioning, the judge indicated he would advise the jurors they would be escorted out of the building in the future. The court finds the record refutes defendant's allegations. Oh, I copied that twice, didn't I? Sorry. As to defendant's second allegation regarding the distracted juror, this matter was also addressed on the record. After a recess, the trial court took testimony from Nancy Long, a producer for a news show. Miss Long testified a male juror approached her and asked, "What are you doing over there? Are you transcribing?" When the juror was brought into the courtroom, he explained that he asked Miss Long if she was recording or something. "I didn't know what she was doing, but because of the clicking, I was just curious what she was doing." The juror said he was not distracted because he got used to the noise, and he also said it did not interfere with his ability to hear, see, or pay attention. When the judge asked the juror if anything related to the judge's inquiry would affect the juror's ability to be fair and impartial, the juror responded, no, not at all. Thus, the court again finds the record refutes defendant's allegations that there was a basis for counsel to move for a mistrial based on jury tampering, or on the basis of a juror being distracted, where the juror in question specifically indicated the transcription was not interfering with his ability to see or hear the proceedings. Based on all the reasons above, the court finds defendant has not established deficient performance or prejudice. Accordingly, relief is not warranted on Claim 3. Finally, a claim of ineffective assistance of appellate counsel is not cognizable in a motion for post-conviction relief. Rather, such claims should be presented in a petition for writ of habeas corpus in the appellate court which heard the direct appeal. Accordingly, Claim 4 is dismissed without prejudice for defendant to seek any relief she may be entitled to, if any, under Florida Rule of Appellate Procedure 9.141D, and she never did that. So, It is therefore ordered in a judge that Claim 1 of amended motion for post-conviction relief filed October 9th, 2018 is hereby dismissed without prejudice to any right defendant may have to file within 60 days timely, properly sworn, facially sufficient claims. It is further ordered that claims 2 and 3 of defendant's amended motion are denied. It is further ordered that claims 4 of defendant's amended motion is dismissed without prejudice. For defendant seek relief, any relief she may be entitled to, if any, in the appellate court. It's further ordered that defendant's motion for order of appointment of public defender is all of her motions for appointment are dismissed. On April 9th, 2019, she wrote another letter to the judge.
Yeah.
And in this one, I'm truly sorry to the prosecutor, Abraham's mom, and others that I hurt for not being truthful. I regret my own actions. I'm deeply embarrassed by them, but I have nothing to lose now. My son is in another state, my mother has moved, and my dad has passed away. I am not seeking sympathy or you to twist this letter around. I am begging you to look at the real evidence because I really did not kill him. I always believed in the justice system, but they allowed people they knew were lying to take the stand. I never lied that I was lying. They kept threatening to arrest innocent people. I'm begging for justice to work as it was put in place to do. I did not help matters, but I knew when they fully investigated, they would find out everything, something they never did. Detective lied right on the stand, not caring about the cost. They did whatever they had to do to get a conviction, and that's not right. Give me a chance to show all my evidence, not to be manipulated with lies I can prove untrue. As you watch each and every video and discovery, I was really taping for my book because I could not believe all the things that went on. Some video may never be allowed to be shown because it puts the victim in a negative light, and I completely understand that. It's still not right for prosecutor to allow them to lie just because all the video can't be shown when he knows it's a lie. I know he's just doing his job, but I'm a real person, not just a number. So then she filed
Do judges have to pay attention to these letters, or do they just laugh and then file them?
I don't know. And unfortunately, if I were to call the judge and ask her that question, she would be unable to answer.
Got it.
She would be prohibited from answering me. She filed an amended motion for post-conviction relief on April 9th, 2019. Again, she alleged ineffective assistance, failure to investigate and present exculpatory evidence disproving date of death. Her facts were that Abraham buried money on her property on April 7th, 2009, and told others about it, that the concrete slab was poured on April 13th to protect the money, that DNA test was performed on Abraham on April 28th, 2009, that the results were not completed until April 20th, and Centoria Butler said Abraham told her about the results. Cedric Edom met with Abraham on August 28, 2009 to give him weight gain powder and get a signed birthday card for his mother. The ME's testimony disproves the state theory because the ME testified that Abraham had been buried for only 1 to 2 months and could not testify that he'd been buried as early as April 6th. Defense counsel failed to point out discrepancies between the clothing Abraham was wearing when he was found and the clothing he was wearing in the video taken by Moore on April 6, 2009. And that's one where she said he's wearing a jacket when he's found, which means he was shot and killed during cold weather, not early spring.
That makes sense.
Ground. She then adds new grounds, which is not what she was supposed to be doing, but she does. She alleges ineffective assistance for failure to call witnesses. And the witnesses she says should have been called were Michael Ford, who was another suspect, Miss Orton, who was a Bank of America employee who could have proven that the payment to Hancock was donation to a whistleblower program. Courtney Daniels, who was a girlfriend of Shakespeare's, who would have impeached Centoria Butler. Greg Massey, who was another suspect, Antoinette Andrews, who was also another suspect, Cedric Edom, who could have testified about time of death, Kathy Weedman, who could have also testified about time of death, and Detective David Kavanaugh, who could have testified about time of death. Ground 6, prosecutorial misconduct for failure to disclose material information favorable to defendant in violation of Brady. She alleges her statements were manipulated, that Ronald told her that Abraham was shot twice after being held for several months by drug dealers. According to the autopsy report, Abraham was shot 3 times, that photos shown at trial were presented in such a way that the jury would think Abraham was only shot twice. Abraham's jacket proved he was killed during the winter months, not early spring, that counsel should have objected to the omission of crime scene and autopsy photos demonstrating a third bullet hole in Abraham's shirt, and failed to show discrepancies between how Abraham was dressed in Moore's video and how he was dressed when his body was discovered, and that there were additional videos that were requested and not produced in defendant's discovery, or to defendant in discovery. Ground 7, prosecutorial misconduct for knowingly allowing false testimony of witnesses at trial. And these were allegedly Centoria Butler lied about her knowledge of Abraham bringing money. Detective Wallace lied about connection between Abraham and drug dealers in Polk County, including Samad Saeed, Eddie Dixon, Greg Smith, Cedric Edom, and Moore looking for a fall guy for Abraham's murder, and that Detective Clark lied about Moore looking for a fall guy for Abraham's murder. Ineffective assistance, ground 8, for failing to impeach witnesses for perjured testimony. And this was Centoria Butler. There's a video with a conversation between Abraham and Moore regarding Butler, a taped conversation between Roger Kennedy and Antoinette Andrews that would have impeached Detective Wallace regarding alleged connections to drugs for Abraham. Excuse me, I'm so sorry.
Bless you.
All right, sorry about that. Oh.
No, you okay?
Yeah, my throat's getting dry. So, and then, so that was a connection, Detective Wallace, Abraham's connection to drugs. Detective Clark, tape conversation between Greg Smith and Moore show that Greg Smith suggested finding a fall guy, not Moore. Ground 9, failure to file a motion in limine regarding highly prejudicial interrogation by Detective Clark. Clark testified that after an interview with Moore, she told him she could get a free room at the Hard Rock Casino and offered to take him there to perform sexual acts on him. Moore's trip to Las Vegas was taken in March 2008 before she met Shakespeare. The state misrepresented the cell phone information to the jury, and Clark threatened to arrest Moore's boyfriend, and she admitted to having Abraham's cell phone. To get her to admit to having Abraham's cell phone. Ground 10, failure to object to highly prejudicial interrogation tapes played for the jury between Clark and defendant, which was the same as ground 9. Ground 11, failure to show the defendant was not in possession of the weapon that was actually used in the crime. And that was testimony at trial showed that the bullets recovered from Abraham lacked identifying characteristics necessary to link him to a specific firearm. Greg Smith asked defendant for a gun to give to the individual that he was setting up as fall guy. The defendant gave Greg Smith a gun she purchased long before she met Abraham, and Greg Smith gave the gun to detectives and alluded to the fact that it was the actual murder weapon that he obtained from defendant. Now, her giving the gun to Greg Smith is all on tape. And now poor Kyle is not connected. Oh my goodness. Oh dear. Okay, he's back.
Am I backstage again? This is so...
It said your devices were not connected.
Oh, gotcha.
Yeah.
So this
as I was saying, the whole thing. Oh, sorry.
I'll say stuff's on tape, and she's just denying it. I mean, she's She's definitely, I mean,
Pathological.
it's like, hey, I did it. I got caught. Let me just go away. And she's just
Yeah.
like, absolutely. The sky is not blue. It is purple.
Yeah. No, it's not even, it's like it's yellow,
Yeah, exactly.
because the sun is yellow. And
Right.
really, I would recommend that people watch some of these interviews, as many as you can find, and listen to them, because she just goes on and she just pulls shit out of her ass, almost literally. And it's just like she doesn't remember the lies she told, and she contradicts them. And sometimes, it's like A does not connect to B. And in some of the interviews, they would ask her, well, that doesn't make sense. But what about this? And she would just like look at him, like not computing.
Yep.
You would
Yeah.
see a little circle
Right.
buffering. She also alleged ineffective assistance of counsel to present a reasonable hypothesis of innocence to the jury. This is ground 12. The case was wholly circumstantial with no physical, material, or scientific evidence linking her to the crime. The murder investigation was inadequate because law enforcement was singularly focused on tying defendant to the murder while overlooking other potential suspects who also had motive and opportunity. But nobody had all of Abraham's money and stuff.
Right.
Only
And
you
ignore
had
the
that, Dee Dee.
video. Yeah. Ignore the fact that he's buried in your house.
Well, no, I mean, this is before they even knew that part, but they know they've got his bank records. They know where his money has gone,
Right.
and they know what she has done, because she, luckily, like I said, she's not bright at all. And this is why she's such a miserable failure.
Yeah.
She gave them access to all of her bank records right off the bat in November. So they've got all these records. They see money coming in and going out. There are no fingerprints linking her to Abraham's body or any of the materials lying about around his body or the tools that were used to bury him. There's no DNA linking her to Abraham's murder. There's DNA suggests an alternate suspect at the crime scene, and there's a mixed DNA profile from swabs from the carpet at the crime scene that demonstrates the presence of at least two persons and excludes Shakespeare and defendant. Ineffective for failure to present video, audio, and receipts to show prosecution theory is untrue. There's an audio recording of between Greg Smith and Nathaniel Thomas showing that defendant was justifiably concerned for her family's safety due to threats by Zaid. Greg Smith played this recording for defendant so she will take their threats seriously and let him help her because they have set her up. Counsel should have deposed Thomas. Zaid lied about the last time he spoke to Abraham and claims that there were Lakeland police officers involved who had been paid off by drug dealers. Now, the only one proven to have been paying off a Lakeland police officer is who? Kyle? Were you paying
Dee Dee.
attention? That's it. And, it's also funny, like Greg Smith acting like Greg Smith came to her to get her to let him help her, because he's tied up with these drug dealers, even though she went to Greg Smith and said, I'll pay you to do this. I'll pay you to call Miss Walker on December 28th and pretend to be Abraham and come with me to this hotel so I can, and help me write this letter to Miss Walker and then deliver it to her. I mean, it's like, Lord help me. She is really not bright. She's not the sharpest crayon in the box.
But hey, she doesn't give up. She just keeps, she doubles down on the cray.
She doubles down on the cray for sure.
And there's no self-awareness, no ever thoughts that, it could be me. It's not you, it's me.
All right. On July 10th, 2020, the court entered an order to respond in part and denying in part defendants' amended motion for post-conviction relief. And I'm just going to kind of summarize this one because we're getting close to the 2-hour mark. He
Basically,
found
the court just keeps saying you're crazy and wrong.
no, actually no. Claim 1A, the court found to be facially sufficient and ordered the state attorney to respond. The court found 1B to be facially sufficient and ordered the state attorney to respond. The court found claim relief was not warranted on claim 1C, which was alleging that Dr. Bill Bash should have been called to testify as to how long Abraham had been buried or how long he'd been dead. And part of the reason that doesn't fly is because in interviews with the police, when she finally admitted to Abraham being murdered, she said it happened on April 6th. Multiple times. So that one has no merit and doesn't warrant relief. Claim 1D, again, without merit because she said he was killed on April 6th. So trying to say he was alive after April 6th is not going to fly. As to Dee Dee's alleged witnesses, found that claim 5 is without merit. And Kyle has lost connection again, so I'm going to give him a little text real quick and take a break and let my throat stop. Okay, he's back. Okay. All right, Kyle, welcome back. You're just having technical issues galore today.
On this when my my headphones are have a little short in them, and I think sometimes when they get moved around, it thinks that I've disconnected.
Oh, okay, gotcha. All right, so witnesses. Claim 5 about Michael Ford was found to be without merit because her claims about loans made by Shakespeare and evidence of other suspects who did not want to repay loans is entirely speculative. And the jury had been informed that Shakespeare had a lot of debt on the streets. The court found the allegations as to Ms. Orton to be facially sufficient, so ordered the state to respond. The court found the allegations regarding Ms. Daniels to be vague and conclusory, and she fails to allege what Daniels would have said on the stand to impeach Ms. Butler's testimony. So it basically gave her the opportunity to cure her prior deficiencies, and she doesn't get a second opportunity to do so. Also, the state played interviews of the defendant by law enforcement for the jury. Those interviews reflect that although she repeatedly blamed persons other than herself, she never implicated the informant, which was allegations against Greg Smith, I believe. And so her now trying to implicate Greg Smith is just not worthy of belief. Oh, wait, no, it was Greg Massey was an informant. Never mind. Anyway, claim 5 without merit. Claims that Antoinette Andrews were facially sufficient. And so he wanted the claim 5E, wants the state to respond. Again, claim 5 was denied as to Cedric Edom because sorry, I'm buffering. It was already addressed as subpart B of claim 1. Again, the day of death, she told police it was April 6th. Claim 5H, claim 5G, ordered the states to respond as to Kathy Weidman. Claim 5H without merit. Other than Ms. Weidman, defendant does not identify who allegedly saw or talked to the victim after the alleged date of death. And again, she said it happened on April 6th. Claim 6 found to be without merit for several reasons. First, she has an alleged Brady violation. Instead, she's complaining about the state's choice of evidence. Next, defendant's allegations regarding the discrepancies between the clothes worn by Shakespeare in the video and the clothes found with his body were addressed in Claim 1D, and she's not entitled to further consideration of the same issue a second time. So that was already dismissed. He also cites the medical examiner's testimony regarding 2 bullet holes to the left side of the chest and 2 bullets being recovered from the body. She did testify to 3 holes in the jacket and shirt. She explained 2 of the holes overlaid the entrance wounds, and the 3rd hole could have been a graze wound or something else. Thus, regardless of what the pictures depicted, the jury was aware there were 3 holes in both the shirt and jacket. So that claim is not a cognizable Brady claim or violation or prosecutorial misconduct, and so it's not doesn't warrant relief. Subpart A of Claim 6 is also without merit. Contradictory testimony does not establish a Giglio violation. And I hope to God she doesn't read about Richard Glossop's case. The court did not err in denying this claim, so she can't, excuse me, I'm reading ahead too far. Second part of subsection B, that Detective Wallace twisted the facts to make it look like defendant was looking for a fall guy for the murder. The court finds that Detective Wallace's testimony was not perjured. The informant, when testifying about one of his conversations, testified that the defendant was asking me, what if they find Shakespeare dead and who will we blame? And she came up with this guy, Ronald. Additionally, one of the recorded conversations between the informant and defendant included a discussion of hiring a fall guy. Thus, Wallace's testimony was consistent with the recorded conversations. Also found Clark's testimony consistent for similar reasons, because again, this is the recorded conversations between Smith and Moore speak for themselves. And you can take an isolated piece and say, look, see, Greg Smith suggested a fall guy. But then earlier in the conversation, it's Dee Dee Moore proposing a fall guy. Claim 8.
Get out of context.
Failing to impeach witnesses with perjured testimony. These are the same that she alleges in Claim 7, and relief is not warranted on Claim 8. The court finds the extended portion of Claim 8 to also be without merit. There was a hearing outside the presence of the jury regarding impeachment of Ms. Butler based on the video. Thereafter, counsel attempted to impeach Ms. Butler on the issues of domestic violence, about sale of Mr. Shakespeare's assets, and about her knowledge as to whether the victim had AIDS. Defense counsel was able to establish inconsistencies in her statements on the video, but Ms. Butler repeatedly asserted that she lied on the video because guess what? Dee Dee told her to lie. And this is what Dee Dee did with Antoinette Andrews and Centoria Butler, is went to them and said, I'm going to help you clean him out, but you have to do this for me. And then would videotape him making statements that benefited Dee Dee. So in light of her statements that she lied on the video and that defendant instructed her how to answer the questions, the court finds further impeachment of Ms. Butler based on statements in the video would not have resulted in a different outcome at trial. So extended Claim 8 has relief not warranted. Claim 9, the 2 unidentified statements which weren't recorded regarding the sexual advance and vacation to Las Vegas, and failure to introduce the cell phone records. That also doesn't warrant relief because the objections were made at trial and the court overruled finding the recordings to be relevant and finding any prejudicial effect was not greater than the probative value of the circumstances. The court finds a different outcome would not have been reached, and counsel tried to exclude the information via a motion in limine and through an oral objection. 12, subpart B, that defendant responded to the question by answering, yes, actually, that was before. The record further reflects that the jury had already heard defendant describe how Mr. Shakespeare gave her $1 million. In light of defendant's admissions that Shakespeare gave her $1 million, the court finds the brief exchange about a vacation to Las Vegas did not affect the outcome of the trial, so relief is not warranted. Subpart C, failure to submit the cell phone records. The state was ordered to respond. Claim 10 without merit as subparts A and B. Essentially, it was raised in a motion in limine, and raising it as an objection would not have changed the outcome. So, subpart C ordered the state to respond to 9C. Allegations regarding the fall guy. Defendant initially raised this issue in Claim 7. The record reflects defendant asked the informant to coach her on what to say to the proposed fall guy. The record reflects defendant asked the informant, what does he want? Just his canteen, and commented, I'm going to have to sell something if he wants something. Thus, in light of defendant's participation in the conversation, the court finds counsel's failure to play the portion of the recording allegedly showing it was the informant's idea to come up with a fall guy and showing that the informant asked defendant for a gun to give to the fall guy does not undermine confidence in the outcome of the trial. So, claim 11 without merit. State ordered to respond to claim about the failure to object to the gun and the ballistic evidence. Claim 12, facially insufficient as to a vague and conclusory allegation regarding perjured testimony, inadequate investigation, and alternate suspects. As claim 1 was filled with such facially insufficient allegations, and the court gave defendant an opportunity to cure her pleading deficiency, the court finds it's not required to give defendant an opportunity to cure her instant pleading deficiencies. So claim 12 is denied, in part as to the vague conclusory allegations regarding perjured testimony. Failure to present the DNA evidence is also found to be sufficient. So claim 12, the state is ordered to respond. Claim 13, facially insufficient, as it's confusing, vague in parts, conclusory in parts, and alleges numerous disparate claims for relief. Claim 13 was not filed in accordance with the court's prior instructions. So that's denied. And so the state's been ordered to respond to claims 1A, 1B, 5B, 5E, 5G, 9C, 11 in part as to the allegations regarding the gun, and 12 in part as the allegations regarding DNA evidence, and then claims 1C, 1D, 5A, 5C, 5D, 5F, 5H, 6, 7, 8, extended claim 8, 9A, 9B, 10, 11 in part as to the fall guy allegations, and 12 in part as to the allegations regarding perjured testimony, inadequate investigations, and alternate suspects, and 13 are all denied. The state of Florida filed a response on August 25th, 2020, and they reiterated some of the salient facts that prove basically that Dee Dee Moore is guilty of sin, which I'm not going to reiterate other than to say she had her husband dig a hole. She had him come back and fill the hole. She had concrete poured over the hole. And she said he died on April 6th.
And what remind me, her alternate explanation was that was where the money was buried?
Correct. She started claiming in post-conviction that The hole was dug for Abraham to bury money,
Got it. That's what
even though she had all his money.
I.
He didn't have any money left. She had already taken all of his money.
Should have gotten a
She
big
got all of his
mattress.
money in February. So, and I'm not going to go into the states. It's an 8-page response. I'm not going to go into all of it, but basically, they refute the majority of the allegations. Although they do admit on a few of the claims, I'm going to go through the ones that they admit. They admit that Claim 5E, nothing in the record conclusively rebuts the claim, and accordingly, a hearing is warranted. Then claim and then also on Claim 12, an evidentiary hearing is necessary to resolve this issue, and that's regarding the DNA. And then in March of 2022, Antoinette Andrews dies. There's not an obituary, so I don't know an exact date of death. I just know there was a GoFundMe posted by her family. So obviously,
Wait, the lady that
she
won
no
the
longer had her lottery
$1
money.
needed a. I think it's just practice now. There's a segment of the world that just anytime anything happens, even if they're billionaires, they post a GoFundMe.
Yeah. So anyway, well, it's entirely possible because Antoinette Andrews, according to some articles, had a bit of a gambling problem and maybe a bit of a drug problem. So she may have blown through that money in 5 years.
Yeah.
So on July 18, 2022, the court entered an order granting an evidentiary hearing in part and denying in part defendants' amended motion for post-conviction relief, and setting a status conference on August 18th, 2022, and appointing the Office of the Public Defender. So the court found that in light of the defendant's recorded conversations with Mr. Smith about finding a fall guy and buying time, and in light of defendant's numerous admissions about witnessing the victim's death on August 6th, and in light of Ms. Butler's trial testimony about when she last saw the victim, the court finds even if the paternity test or Ms. Butler's hearsay testimony about what the victim allegedly told her in May of 2009 had been admitted, such evidence would not likely have resulted in an acquittal considering the other admissible evidence. Accordingly, relief is not warranted on subpart A of Claim 1. And basically, another problem with that DNA, quote, evidence is that it's a submission form for a DNA sample. And guess who the client is on that submission form? Not Abraham Shakespeare.
I bet it rhymes with Cece.
So she could have gotten some kind of sample from him and then sent it off. And also, it was ambiguous as to whether the form was completed and sent off on April 28th or whether it was received by the lab on April 28th, having been sent off at an earlier time. So it was a bit ambiguous. And this is another thing when you read her things, it's like, well, this video will prove, and then that video doesn't prove shit. Because that video is not who you say talking about what you say they talked about, but it's you saying that they said.
Right.
And another funny thing that we saw, and again, this comes out in her interviews, is she says, well, this person told me this, and it's like, Dee Dee, we talked to him. He said, Dee Dee told me that. So it's like she plants these things and then tries to say that they said it to her first. Next issue, again, As to Cedric Edom, in light of her numerous versions of how the victim died on April 6th, her admission that Abraham didn't sign the birthday card, and his statement during a recorded phone call with Moore, in which he stated he last saw the victim in April, the court finds a subsequent statement from Mr. Edom contradicting his prior statement to defendant and defendant's statements to law enforcement would not likely have resulted in acquittal. So subpart B of claim 1 is also dismissed. The court finds the statement regarding the state's argument regarding Ms. Orton could not have rehabilitated defendant where the record reflects defendant made inconsistent statements about how Abraham died, asserted the victim traveled to several locations for AIDS treatment, despite alleging she witnessed his death, asked individuals to falsify contact from the victim, attempted to remove the victim as a signatory from an account with over $1 million in it, and where Mr. Hancock testified he never assisted defendant in identifying whistleblowers. The court notes that Mr. Hancock testified the check was given to him in part for helping identify potential tax evaders, which defendant asserts is what Ms. Orton would have testified to. Thus, the court finds Ms. Orton would not have provided new information to the jury, and at the same time, her testimony would not have been inconsistent with Mr. Hancock's. Because this is what she tells Hancock. She tells Hancock, I bust tax cheaters, but I feel so sorry for Abraham, I want to help him. And I'm not going to bust him.
Huh.
And then allegedly, like I said, the check is supposedly a donation to Bank of America, a gazillion-dollar corporation, to fund a whistleblower program.
Yeah, that makes no sense.
You know, I mean, it's just like purchasing ISBN does not mean you're going to write a book. It means you want to write a book, but it doesn't mean you're actually going to complete a book. So relief was not warranted on 5B. Let's see. An evidentiary hearing is warranted on claim 5E. And then also no relief is warranted regarding Kathy Weidman, which is 5G. So that claim is dismissed. And again, finds the relief not warranted on claim. I'm forgetting. Let's see. I sometimes miss the numbers. Not warranted on a claim C, but I'm not sure which one because we've done 5G. Regarding Detective Clark. And, you know, this is the inconsistent statements made by Dee Dee to the detectives. Basically, her new claims don't pass muster. So relief was not warranted on claim 11 in part as to failure to object to admission of the gun. And so basically an evidentiary order, an evidentiary hearing was ordered on claims 5E and 12 in part as to the allegations regarding the DNA, and claims 1A, 1B, 5B, 5G, 9C, and 11 in part as to the allegations regarding the gun were denied. The Office of the Public Defender was appointed for limited purpose of representing defendant at the evidentiary hearing and setting a status hearing for August 18th. Notice of hearing setting an evidentiary hearing on November 29th, 2022 at 1:30 p.m. was filed. The public defender, Rachel Reese, files a notice of appearance and designation of email. A motion to withdraw the public defender was filed, and I should have looked at it to see if Reese is actually a different entity, because I believe the public defender's office had a conflict. So
Like a
then they're
conflict
just,
of interest?
yeah, because they probably represented people that could theoretically testify against Dee Dee.
Gotcha.
And I think that's like there are docket entries, but there isn't an actual document. So I probably should have just left that off because it's freaking confusing. Status hearing was held on December 8th, 2022, and the evidentiary hearing was reset to March 8th, 2023. The state apparently objected, and they were given till February 20th, 2023 to take a writ, which they didn't do. Byron P. Heilman, lead counsel from Dee Dee's trial, died on January 19th, 2023. A motion for continuance was filed on March 3rd, 2023 by Moore, or on behalf of Moore, citing need for additional time to prepare for the evidentiary hearing and meet with Moore. A status hearing was held on March 30th, and the evidentiary hearing was reset to June 28th. Another hearing was held on June 27th because there was another motion for continuance, and the evidentiary hearing was reset to July 12th. The defense filed a motion for clarification and our notice of intended scope on July 11th, 2023, seeking to revive claims related to Antoinette Andrew through admission of 2 recordings from counsel's discovery file and notes of trial counsel that reflect information concerning Andrews for the upcoming hearing, because Andrews is now deceased, and notifying the court and the state that counsel intends to present evidence in support of Claim 5E at the hearing. On the 12th, the state made an oral motion to strike Claim 5E because Antoinette Andrews is dead, and to exclude defense's introduction of the record tape, and that was denied. The evidentiary hearing was held on July 12th. Moore testified, and Christopher Bolt, her second chair counsel, testified. Defense Exhibit 4, which I believe was the tape, was filed under seal on July 25th, 2023. A final order denying claims 5E and 12 in part of defendant's amendment and motion for post-conviction relief was filed on October 19th, 2023. And this, again, is another lengthy order, but basically they found that in the tape, it's not really Andrews talking about fear for Dee Dee's life. It's Dee Dee talking about fear for Dee Dee's life. And that an investigator had spoken to Andrews, who did not have anything nice to say about Dee Dee. And that a lot of Dee Dee's allegations in her pleadings just didn't bear up.
No way.
Surprise. And basically she just did, none of it demonstrated that the outcome of the trial would have been any different had she entered this information. And a lot of it has to do with the changing stories, like her saying that Abraham was dying of AIDS to he was pretending to be dying of AIDS so that he doesn't have to pay child support. And
I mean, she is creative. I mean, props to her creativity.
She is. And she's one of those people that basically, who are you gonna believe, me or your lying eyes?
Right.
Because she constantly swears she's telling the truth. So the court found that defendant has not established deficient conduct or prejudice, and relief is not warranted on Claim 5E. And this is all considering her allegations, the record, and the evidence presented at the evidentiary hearing. She also found that Claim 12 was without merit. That it appeared that Dee Dee had altered her nature of her claim from failure to investigate the 2 minor DNA samples to failure to prevent DNA evidence in a different manner. Alleged failure to investigate the 2 minor DNA samples. To review the evidence, that the evidence didn't meet CODIS criteria for submission, and that the expert did not find anything of concern with regard to the DNA evidence. And you have to remember, the sample from this carpet was not taken until January of 2010. It wasn't taken April 7th, 2009. So if there's a mixture, and Abraham's blood was found, or Abraham's DNA was found, if there's
Yeah.
a mixture of DNA with Abraham's, that could be from subsequent people coming in, because this was a public space that
Right.
she used as an office.
Right.
So, she didn't present any evidence that they could have been submitted to CODIS, or that the results from such submission would have affected the outcome of the trial. As to her complaint about how the DNA evidence was presented at trial, she hasn't presented any evidence that a different approach existed or would have been more effective. So the court found defendant's testimony that jurors did not understand the DNA evidence to be speculative at best, which is not a basis for post-conviction relief. So claim 12 was denied. So 5E and 12 were both denied, and she had 30 days to appeal. She filed a notice of appeal on November 16th, 2023. She requested appointment of counsel and extension of time to file her brief, alleging police corruption, that recordings of proof witnesses were lying, destruction of files by the sheriff, that she was not given enough time to present her case, and that the prosecutor introduced things that were outside of what was granted for the hearing. Because the beauty of it was the prosecutor got to cross-examine Dee Dee because she testified at the hearing. And he confronted her with all her statements, and she tried to say, well, I wasn't allowed to say that because they were threatening me.
I was going to say, that sounds like an S show.
A jury would not have found you any more credible than a judge did, babe.
Right.
Order issued on April 17, 2024, denying in part and dismissing in part her motion for appointment of counsel and extension of time to file a brief. And basically, it's not necessary to appoint counsel to represent defendant in her post-conviction appeal. The ruling does not preclude her from seeking appointment of the appellate counsel through the appellate court. And the court was without jurisdiction to grant her an extension of time to file her appellate brief, because that motion was denied. The case then goes to the District Court of Appeal, 2nd District. A miscellaneous order was entered because the counsel appointed to represent her at the hearing could not represent her in appeal. So they had to withdraw. And ordering that she would proceed pro se without prejudice to retaining new counsel. She was additionally advised that she may have the right to appointment of counsel. But I guess she had to go back to the trial court for those things. I'm not really, again, they don't have things available to look at.
Is that just a Florida thing, or?
That's the way Florida handles post-conviction, yes.
Gotcha.
That's the way Florida handles post-conviction. Her initial brief was filed on April 16, 2024. She filed a motion for appointment of counsel, which was denied without prejudice for her to first obtain a ruling in the circuit court on her motion for appointment of appellate counsel. And if it was denied, to follow in this court a motion to review the denial. They also granted her extension of time to allow her to file an amended initial brief, together with a motion to strike the initial brief within 30 days of the order. She did file a motion for review on May 20th, 2024 for the denial of appointment of counsel. She filed an amended initial brief on the 10th of June, and a motion to strike, but she said to strike the answer brief, which was never filed. So I think she got confused. An order was entered on the 13th of June, which reviewed the trial court's order denying and dismissing the motion for appointment and approving of that order. They also, I think because her amended brief was filed out of time, because she had 30 days from May 7th, and it was filed on the 10th of June. So they accepted the amended initial brief and struck her initial brief. But they cautioned her not to file additional amended briefs without first filing a motion for leave to do so. An answer brief was filed by the state on the 15th of July. An order was entered on the 8th of August. She was seeking a 90-day extension for appointment of appellate counsel, which was denied. And the court found that it was not necessary to appoint counsel to represent defendant in this appeal, and the trial court's denial of appellate counsel was approved, so appellate counsel would not be appointed. A reply brief was filed on August 19th by Moore. She filed a motion to supplement the record on October 4th, which was denied. And then on the 18th of November, the appellate court entered an order requesting copies of the order granting evidentiary hearing. Supplemental record was filed on November 19th, 2024. A disposition was made on the 4th of April, 2025, which affirmed the trial court denial of the remaining claims. She filed a motion for a hearing and or written opinion on April 23rd, and that was denied on May 5th, 2023. And so that is, she has 90 days to go to the U.S. Supreme Court, which expires in August. Yeah, I think in early August. She hasn't sought review by the Florida Supreme Court. She probably will not, because she hasn't done that before. So that's the end of the litigation for Dee Dee Moore. She's serving life without parole in Lowell with Dalia DiPolito. So I wonder if those two little lying liars get together and tell some tall tales.
I'm sure.
And so there were multiple actions also filed to try to get the money back for Shakespeare's estate. A case was filed by the estate against American Medical Professionals PEO Inc., which is a company that she formed to take Shakespeare's money. And the personal representative of the estate filed an additional action. One was filed to rescind the deed transferring the property, and another one was filed to set aside fraudulent transfers of the assets and money. And then the estate of Shakespeare on October 7th, 2011, filed a complaint for conversion and replevin, which was against American Medical Professionals and Dee Dee Moore. Conversion by both defendants of money in the amount of $246,493, which was the property of Abraham Shakespeare. Further conversion by Moore on February 11, 2009, the amount of $1,095,000, which was the property of Abraham Shakespeare. And replevin, arguing that plaintiff is entitled to possession of the property because it was obtained by Moore with funds she misappropriated from Abraham Shakespeare. This is the personal property that's been seized. Order on defendant's motion to dismiss was filed on December 21st, 2011. And that was denied. Counts 1 and 2 were permitted to go forward. Count 3 was abated until such time as the felony court determines whether it wishes to determine ownership of the property. And that has not really gone anywhere that I can tell. There have been several appeals, but I can't tell what really happened in the Polk County litigation.
Got it.
I'm presuming that the debts and all those things were awarded back to Dee Dee Moore. I mean, awarded back to the estate. Misspoke. Randall O. Reeder, who was the civil attorney representing Moore in this action, was allowed to withdraw due to irreconcilable differences. An order setting for a jury trial was entered on August 27, 2013. A non-jury trial was set for October 14th, and a pretrial was set for October 10th. On the 14th, the pretrial a non-jury trial was reset to November 15th by agreement of the parties. A final non-jury order was entered on November 15th, granting Reeder's motion and granting him attorney's fees of $11,305 with interest at a statutory rate of 4.75%, for which execution could issue subject to claims brought by plaintiff. And then on November 20th, a partial final judgment was entered. Based upon the evidence presented, the court finds that defendant Dorice Moore converted $246,493 to, which was property of Abraham Shakespeare by electronic transfer, to an account which belonged to defendant American Medical Professionals LLC, and Dorice Moore was the managing member and sole owner of American Medical Professionals LLC. Dorice Moore and American Medical Professionals shall pay the sum of $246,493 to the estate of Abraham Shakespeare, together with interest from January 2nd, 2009, at the rate established from time to time by the Florida Department of Revenue, for which let execution issue. They reserve jurisdiction to award plaintiff any costs incurred and announce voluntary dismissal of count 2 without prejudice. And count 3, replevin, remains with the court in which the criminal proceeding against Moore was conducted. An acknowledgement of new case was filed at the Court of Appeal, Dorice Moore versus Christine Miller. That was affirmed on May 13, 2014. Per curiam, a mandate issued on June 11th, and the same mandate issued on June 25th, 2015. So that's final. Hopefully they were able to get that money back. Then Miller, on behalf of Shakespeare's estate, filed an action in Polk County against Bank of America. And that was filed on April 29, 2013, for negligence and breach of fiduciary duty, seeking to recover $1,095,108.98 from Bank of America. Prior to being served, Bank of America removed the action to federal court because Bank of America is a corporation in one state, and the estate of Shakespeare is a Florida resident, or an entity in Florida. So they removed it based on jurisdiction, diversity of the parties, which I get to do a lot at work. Yay. Venue then went to the Middle District of Florida, United States District Court. The docket number was 8:13-CV 1425, before the Honorable Virginia Maria Hernandez Covington. A proposed amended complaint was filed on June 27, 2013, seeking to add claims for negligence and breach of fiduciary duty against Hancock and fraud against Moore, which would defeat diversity because both Hancock and Moore are domiciled in Florida. The estate also filed a motion to remand based on that amended complaint, citing no jurisdiction over Bank of America because it hadn't been served, and the intent to amend the complaint to add Hancock and Moore, which defeats diversity. Motion to dismiss was filed by Bank of America. The estate can't prove they did anything wrong, and too bad, so sad, it sucks to be you. The estate filed an opposition to the motion to dismiss on July 12, 2013, requesting that it be held in abeyance until the motion to remand was decided. The bank filed an opposition to the motion to remand on July 17, 2013, citing that the waiver of appearance, it waived its appearance, so the jurisdictional arguments were defeated. That the plaintiffs had not moved to amend, so the intent to amend isn't real or doesn't count, and urging that the post-removal attempt to join additional parties should be rejected because plaintiff can pursue her claims against Hancock and Moore in state court, independent of the action against Bank of America. On July 19, 2013, the court entered an order granting Miller's motion to remand, and deeming the proposed amended complaint filed with the court as of the date of the order, and directing the clerk to remand the case to state court and close the action once that's done. Then on October 30th, 2013, Miller filed a second amended complaint. There was litigation. I think there were motions to dismiss. They did discovery. And on April 8th, 2015, a joint stipulation of voluntary dismissal with prejudice was entered by Miller and Bank of America. And then on April 16th, a notice of voluntary dismissal with prejudice against defendants Dorice, Dee Dee Moore, and Guy Doug Hancock was filed by Miller. And I suspect that Bank of America's insurance company ended up ponying up at least $1,095,108 to settle the estate's $108.98 to settle the claims.
Jeez.
So that I think Abraham's family, his sons, probably, have been hopefully gotten that money back because they deserve it.
Yeah.
All right, and finally, it's almost over. Yay! I'm just kidding. I'm getting punch drunk. Okay, now the media about the case, because this is a case that's been covered a lot. So we have a special episode, Curse of the Lottery 2, which looked at Abraham's case. That may have looked at other lottery cases as well. They had done an earlier Curse of the Lottery case on E! True Hollywood Story. If E! is even around anymore, I don't know.
Yeah, I don't know either.
I stream, so I don't watch broadcast TV unless there's something, like I like watching Ghost live when it first airs rather than streaming it on Paramount. So sometimes on Thursdays I'll put Ghosts on. Although I don't do that much anymore. She was on Lockup, September 3rd, 2011, season 11, episode 7, Tampa extended stay high profile. And if you can find that episode, she is, her craziness is just front and center, and if you watch it, you can see why her attorneys thought maybe she's not competent to stand trial. And I think one of the other problems is she can't understand when people don't buy into her lies. So they're working against her if they don't buy into her lies. And that's probably why her attorneys didn't want her to testify, is because they can't support perjury. The case was covered on American Greed, June 13th, 2013, season 7, episode 11, The Lady Killer. That was a really good episode. And that's where you get to see some of the hysteria that is Dee Dee Moore. Because one of those interviews that I cited to one of the TV stations, she's in a truck, and I think she's coming out to the media that's at the gate of the subdivision and talking about this money. It was a curse to him, and now it's a curse to me. And she's crying, and I can't believe they think I would take a gun and I would shoot that man. I mean, she could turn on the tears.
Yeah.
Like that. It was she was covered in an episode of Deadly Women, July 26, 2013, season 6, episode 2, Money Hungry. I love Deadly Women, except I hated that they didn't focus a single episode on one person. They always did 3 stories. Granted, it was good 3 stories that tied together, but still, I would have liked to have seen a single episode. And then, of course, when you're a woman and you kill somebody, you murder them, what do? Where do you go? Who comes to talk to you? It snapped. September 15th, 2013, season 11, episode 3, Dee Dee Moore. And this is where she gives an interview, and this is where she says, "They're murdering me by the hands of justice."
That's hilarious.
Yeah, you could stream Snapped on Peacock. So I would, in fact, I'm probably going to end up watching that episode tonight. Just to see her say, because they're murdering me by the hands of justice.
That is a pretty good quote, though. Like, that is actually, to her credit, that's a pretty funny quote.
It's a ridiculous quote.
It's ridiculous, but that's why it's so funny.
It was your gun. He was buried behind your house.
It's funny, and
you had the hole dug. You had the hole filled in, and you had the concrete poured, and you brought somebody and said, he's right here, and put an angle iron over exactly where his body would be found. You know?
Yeah, that's the best part of it.
I mean, in and of itself. And the fact that you know he's dead as of April 6th, but you tell people he's out of town. You're sending text messages. You're writing letters to his mama. He's illiterate, and she wrote a multi-page letter. Indignant that she didn't recognize his voice. I mean, come on. And if you could see some of the Greg Smith recordings, and Greg Smith is one of the heroes in this too, because when he started helping the cops, I guess he didn't want to be wired. So, because he wasn't sure what Dee Dee might do or suggest. So he actually came up with hiding a recording device in a Red Bull can that looked like it was a can he used as an ashtray that sat right between them during every conversation. I mean, if that's not brilliant, in some of the interviews, again, watch Snapped and some of these other shows, which I'll get into in a minute. I mean, they had, like I was a narcotics officer, and this is brilliant. Praising him. So, and he was willing. At first, he was willing to help Dee Dee, but when the cops pulled him over, like, "What are you doing?" He's like, "Wait a second, no."
Yeah, he's
I will help you. I will not help Dee Dee anymore. So, and I think Dee Dee was telling people like Cedric Edom and Greg Smith, they owed money to Abraham, and she's like, "I'll forgive it and I'll pay you." So, Then there's A Stranger in My Home, November 24th, 2013, season 1, episode 7, Death by Lottery. 2020 did an episode which aired on March 22nd, 2014, season 36, episode 35, Bum Luck, which is again has an interview with Matt Gutman with Dee Dee Moore at Lowell. And her reasoning for why she's innocent is, I like Mickey Mouse and Donald Duck and Disney. I wouldn't kill somebody. And she tries to show him a letter, and it's like, that's your handwriting, Dee Dee. And she's trying, when she was at lockup, she was trying to sell her story for money to hire an attorney. So, and hopefully nobody's ever bought this story. In Plain Sight aired February 15th, 2019, season 1, episode 33, The Lottery Murder. Buried in the Backyard, November 18th, 2021, season 4, episode 1, Buried in Money. Web of Death, January 19th, 2023, season 1, episode 1, The Jackpot Murder. Millionaire Murders on Apple TV, April 9th, 2025, season 1, episode 4, The Missing Millionaire. And then finally, most recently, ABC's 2020, April 18th, 2025, season 47, episode 25. It's called Unlucky Numbers. And it looked at the case again. So that's, and there have been Boku podcasts. I didn't even try to go through the Boku podcast because it was just too much. So that is our story with Dee Dee Moore. She has not filed a federal writ of habeas corpus yet. I think she has a year from May 5th of this year. So she has by May 5th, 2026. She's still pro se. She doesn't have anything. She doesn't have attorneys representing her. And it's pretty unlikely because, when you look online, there is not a single group that I could ever find that says Dee Dee Moore is innocent. Not even her own family.
Yeah, I mean, she seems like the most ridiculous. I mean, a lot of them, but I mean, God, I don't even know how you could, with a straight face, think she was innocent.
No. Unless you buy into her claims about, like, one of the claims is she's claiming that there are Lakeland police officers who are being bribed by Zaid, the alleged drug dealer. And it's like, but Lakeland police officers weren't investigating Abraham's disappearance. That was
Right.
Polk County. And they weren't investigating Abraham's murder because that was Hillsborough. But somehow, knowing those cops were paid off, she couldn't tell these other cops the truth, and they wouldn't investigate. I mean, like I said, when you look at her interviews, sometimes it doesn't make a damn bit of sense. There's no logic. Dee Dee was not in line for logic when they were handing that out. Okay?
Right.
She was in line for another dose of the gift of gab.
Yep.
And like I said, I think she is aware of the right to remain silent, but she does not possess that capability because I think she likes to talk to hear her own voice.
Exactly.
So that is Dee Dee Moore. And I told you it was a lot.
He has a lot of legal filings for such a clear-cut case.
Yeah, and that's one of the things. And then, like I went overboard on the orders, and I went overboard on some of the claims. But, I want to try and put it in perspective when I can. But in this case, there was so much that I probably should have been a little more discriminating. Because then when I try to present it and I decide, oh, this is too much. This could have even, in theory, been a two-parter.
Yeah,
But
definitely.
I wanted to get it done. All right, so that is next week is Belmont Stakes. So I'm not going to commit to doing anything next weekend.
Who's your favorite? Who's gonna win?
I'm not. I like journalism and sovereignty. I'm not really. I don't. When the same horses don't. When the same horse that wins Kentucky Derby doesn't run in Preakness and then comes back for Belmont, I'm not as committed. I want to see another Triple Crown.
Yeah.
I every year I want to see somebody get a Triple Crown because I just
Absolutely.
love that and I love that horse. And I've seen Secretariat, Affirmed, Seattle Slew, or Seattle Slew and Affirmed. I can't remember. I always get them mixed up because they were back to back. American Pharaoh, Justify. I was devastated. California Chrome when he didn't win the Belmont.
Yeah.
I mean, I was drunk as Cooter Brown because I'd been drinking all day. But I could not eat that night and I went to my bed and cried
Do
because
you
I
think
was
that was the
so
best
disappointed for him.
horse ever to not win it that had the chance?
Yeah, I do. But he had an unlucky start and he had an injury at the start. And so that impeded his ability to perform as well as he had performed in Kentucky Derby and Preakness races. Because I think he did. I think he had the talent. I think he had the drive. And I think that loss, at least for a time, kind of discouraged him because his record, he had some time off, and it wasn't until he'd come back after that time off that he did well because he ended up going to Dubai, I think, and winning the big thing there. But yeah, I mean, he had an unlucky start in that race, and that kind of defeated him before he was even out the gate, or when he at the time he left the gate, he was already defeated because with the injury, I if Victor Espinosa had completely pulled him up, I would have understood because it was a pretty bad cut on his hoof. Or one of his hoofs, or one of his legs. So yeah, but yeah, I think he's one of the best. And then I was disappointed. I loved Nyquist, and he didn't win the Preakness, and so I was kind of disappointed in that one because I loved Mendelssohn as well, and he didn't really. But he was so cute because he was trained in Ireland, and he was a horse that was very chatty. So in the run up to that Kentucky Derby, and they would show Mendelssohn constantly calling out as he came to and from the track, and very loud, and it wasn't a cultish thing. He was just a chatty horse, and he liked people to know he was coming and going, and what he was up to. And then one of the better ones, American Pharaoh, was awesome, but I think Justify was even better because Justify just had this presence. And there was, when he arrived at Belmont, there was a video and they were walking him up the shed row, and all those horses were just looking at him like, oh my God, I have to run against that because he's huge. And the one other Belmont loss that I really felt was Big Brown in 2008.
Yeah.
And the one thing
He
that
was the one that he broke his leg, right?
no. 8 Bells broke her leg in the Kentucky Derby. She came in second, and she broke her 2 front legs. Big Brown won Kentucky Derby. He won the Preakness. He headed to Belmont, but he had some minor hoof issues. And then the day of the Belmont, I don't think he finished because I think Kent DeSormo pulled him up.
Yeah, that's what yeah.
But they went after, the coverage at that time was on ABC, and they went to the barn, and he was in the big winner's barn still. They hadn't moved him. And he came to the door, and he had his head high, and he looked like, in his mind, he won that damn race. He looked so proud of himself. I mean, I'm definitely anthropomorphizing, but he looked so proud of himself. He had no idea, that somebody else got I think it's white lilies or white carnations or something for Belmont. He had no idea. He thought he won. And so that was like, okay, well, if he thinks he won, I guess it's okay. It's not as sad as I want to make it to be. So, but yeah, he was Big Brown and California Chrome. My favorite going into the Kentucky Derby in 2015 was actually Mendelssohn. And he was 14 and he got mugged and robbed and didn't finish well. But then after that, I was like, American Pharoah all the way. Love him. And really, I wish I'd known more about him before Kentucky Derby because I probably would have been rooting for him. Because he's like a Labrador retriever or a golden retriever in a horse's body. Because Bob Baffert could let anybody come up and touch him, and he's still that way. Even after 10 years at stud. He's still just a very kind horse that likes people and doesn't want to savage them. And Justify is like picky. He likes certain people, but if you're not one of those people, keep your distance. So, because he will let you know. All right. So, thank you for spending the early afternoon with me. It's now afternoon. Happy Sunday. And I think we're ready to call this one done.
Awesome.
What do you
Happy
say?
Sunday.
Any
Yes,
thoughts?
a lot of stuff. No, I just think I'm still shocked at how much. I mean, the same thing I said earlier. I'm taken aback by the amount of court motions and work for just such an obviously guilty case. I mean, it just seems unquestionable, but I know that's the legal system.
Yes. And these were public defenders. And they did. They gave her the best defense that they could, but the evidence against her was so overwhelming. And none of her made up shit is ever going to change that.
Right.
So we'll have to see what happens if she ends up in federal court. Kind of like California, not a lot of Florida people go to federal court. And I guess a part of that is because there's no entitlement to counsel, and so the state doesn't provide that for them. So it's when you're being represented by attorneys, the process is a little bit easier, and they'll throw everything at the wall to see what sticks.
Right.
And when you're doing it pro se, you may not be like she's never sought review by the Florida Supreme Court, even though there are a couple of issues on the suppression of her statements that might have at least been able to get a colorable claim. Of course, again, she had appointed counsel on direct appeal, so they should have and could have had they wanted to, or had they felt that it had merit. But maybe, between their brief and the state's brief, there was no merit. All right, so I'm going to go ahead and we're going to close it out. Thank you for listening to Based in Fact, a true crime podcast. Sorry, people, with Lisa O'Brien and Kyle Evans. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLN. Kyle and I will return in 3 weeks for episode 7, State of Florida versus Ashley MacArthur. MacArthur, a former crime scene investigator, was convicted in 2019 of the September 2017 murder of her friend Taylor Wright, a private investigator and former police officer. We'll talk about Taylor's disappearance and the case against MacArthur, including her trial and direct appeal. Until then, have a great 3 weeks and stay safe.